And those which are which runs on the road, gas is required.
What is required?
Standard or half is required. 0 is half is required.
No, if it is imported, how will that be there? No, you cannot import a tire directly. Yes, directly. Foreign tire cannot be imported. We'll have to pay some duty. No. For instance, if you want to import a tire, you cannot import a tire. You are not a manufacturer. You are a consumer. You cannot import a tire. Yes. If he does not have, what happens?
If I get a tire from,
say for instance, anywhere. Yes, right.
car can be seized. It's also said that these cars should have the cars which should be EIS or any contemporary issued by the branding companies. So that is the law. What happens is I for mining tires. Mining tires are separately classified. Mining tires are separately, and the user is that mining tires should bear the stamp of the road tire on the sideboard of the tire, so that everybody can read, and all the credentials of it should be marked on the body. That to for mining purpose. Very important. This tire has been used. One of my two consignments was genuinely qualified all the things. And I qualified all the things when they said that the tires are very good. And though it is for mark of the road tires, but this is a tire which maybe by someone for running on the road. On the possible misuse or is that one can misuse it and to avoid the offense of law, it will make law if you are to the court, it will use so much of the burden.
Not worth. Not economically viable.
So these laws are really important and you allow it. He says that and for the testing agency asks the question whether this item is FBI is biased or having all credits. The testing says what bias should the testing agency and 8-10 months without they get this question answer. When one answer came that it is all right, it is class that your PIS is not required, but because it has all they say now that say that this should be answered. This should tell me these are the problems on the road. They say that it starts on the road, they are prohibited by that. So now, after the final report came, this is reduced and without any reason. When the entire investigation was completed, after the final report, without any reason, per day damage charge is about 30,000 rupees. If nobody can see the photo,
I'll take it up. Yes, sir. I'll take it up in second call. Ask Mr. Banerjee to be here. Yes. Next.
I can put 3 also.
3 also same. You are there, Mr. Mehta, same. Identical issue. Yes. Passover 323 Passover.
4-2, I would require Passover because I have to obtain a copy from him. I am here, only 5 minutes Passover, my lord. I'll just go through his brief because I've been told that they could not find it. So I'm not saying that.
What
they
is
have
the
not
matter?
missed-
Let's get ready
Yes,
together.
Yes, my lord. Only 5 minutes Passover.
Let's get ready together. Imported slack wax.
Those were provisionally assessed for the purpose of test and without the final testing and final assessment being done, they issue the scope of first and challenge the so-called that final assessment has been done. In that case, there cannot be short term proceedings for the state. Thereafter, we have to on the single test that this that final assessment actually thereafter they proceed and pass it on. I prefer that. The final assessment, unless it is being done, there cannot be short. So,
This is under section 18.
28.
Under 28.
See, so,
Yes. So finalization is under section 18. Under correct. Assessment of duties under 17. Yes. Provisional assessment was completed in your case.
Yes.
Obviously, because when it was imported, final assessment was not done.
Watching the order of the case, so
So final assessment was completed when? No, when date? Okay, 2009 you had imported, provisional assessment made, 12th August 2014, final assessment made. Thereafter what happened?
The same. As manufacturing same so-called supplier. But after I do the reading of sections, etc., and then I do the sort.
What cross-examination for what, Mr. Mehta? That is a department they are saying. Now, how can you cross-examine the departmental representative? Yes, yes. That I understand. Yes, yes, yes. I see. I see. I see. I see. So you sought for cross-examination of that particular person.
For 8 years, Madam famous, I asked that if you have asked any of the item, but I prefer
Tribunal allowed that or rejected?
And it was never
Admitted position? No. Admitted position.
what happened when tribunal allowed
Appeal from?
the recusing process. I was not there.
I see. So,
They were
oh, very well, very well. So, very well.
they were tribunal members. Very then they put what that order in the state. We are and both said now it is proceedings which is something that government actually pass the same order. I will pass the same order here.
Without the previous order being recalled.
Just record. District order, he passes same order, same day. I reiterate the order passed by earlier. There are two orders.
Yes, madam. You need to take instructions.
I'll kindly just
I'll admit the petition, take instructions. Because you see, what I've understood from what Mr. Mehta has said, that after whatever may be the drawback on your part in proceeding under section 28, correct, right, wrong, indifferent, we are not concerned today with regard to that. You had proceeded under section 28 despite the final assessment order under section 17. By treating that you can proceed on the basis thereof, since you relied on certain statements, they had preferred an appeal from that order, since you did not afford opportunity of cross-examination. Now, in the interregnum, you pass the final order. This fact was not communicated to the tribunal. Tribunal ultimately disposed of the matter by permitting you to afford him opportunity of cross-examination. What you did, you again give me opportunity, notwithstanding the previous order was already there. You ought to have approached the tribunal and indicated, kindly set aside that order. So, prima facie, your action cannot be sustained. Take instructions on this, because two orders cannot survive together. Unless the previous order has been set aside, how could you permit cross-examination and reopen the entire issue? You cannot be, you have no power under the, do you have a power under the provisions of this act to review your own order? So unless you have a power of review, you could not have reviewed your own order. So therefore, this fact was not brought to the notice of the tribunal. So now, since this matter is before this court, I'll correct this position. I'll permit you to rehear the matter. But the orders have to go. And I regularize it. Take instructions in the matter. Yes, yes. How? The matter is here, only first up. Today is the last date. When was the matter filed? 16th April. No, the matter is here, madam. No, I am hearing first call the matter. Within first 10 matters, why should I adjourn? No. You get ready. I said you get ready with the matter now.
That is what
Now, get ready. Give me a file. You ought to have brought your own file.
No, I tried to.
What? But your department did not hand over you the file. No, let me understand the situation.
The last occasion, I have intimated this to my landed senior counsel of the writ petitioner. On the last occasion means yesterday, I have intimated this to the department.
That you have not been favored with a copy. So that indicate me that this particular issue, I will protect you. For that, they are not. You just tell me that your office is not giving you the papers in time.
No, they have said their submission was to me was they have not received the concerned.
Let me find out. Say so. Let me find out on the affidavit of service. Let me find out. Hey, down affidavit of service down. I have to test out because your officer cannot go scot free.
It has gone when it has reached 5 days, not 16th April.
Yes, madam. Who is instructing you?
Departmental law.
Let him come. Let the gentleman come here. This cannot continue. This is not the only isolated matter. Other matters also this situation is happening.
It's not sub to the legal section.
Sub to the
Legal section.
It is service is complete.
it is yes. It is to the Commissioner of Customs Board, not the concerned department. So it takes
Legal,
time.
not the
Who are the parties?
Concern.
Who are the parties?
Customs.
Who are the parties?
Commissioner of Customs.
But it is
it has not reached to the legal
it
section.
must have
It
by
has not reached to the
by now. So the process of
Who are the parties, madam?
not the Commissioner of Customs Board.
They have served.
Yes, sir.
Yes. Service is complete, madam.
section.
Then
The-
yes, service is complete as far as the Commissioner of Customs Board is. It is at the Shebuttam, e-Seva line.
Then it goes to the legal section one.
It is at the central receiving section. It is. But the Shebuttam means the central receipt of the office. The Commissioner of Customs.
That is entirely for you unless you have issued a circular that all matters have to be filed before that authority.
It has been communicated to the writ petitioner. It has been communicated with us.
Why will the writ petitioner serve you?
I am there to assist within 5-10 minutes, my lord. I'm only.
No, that is a different issue altogether. That is a different issue altogether. You tell me, madam, that
Difficulty, my lord, to the other side.
let me understand, madam. You say that this has not been served appropriately. Now, let us find out.
Not said appropriately means the Commissioner of Customs is in the address. It has been served at the central receipt section, my lord. There is a short communication gap maybe on my side. I am unable to communicate. My lord, there is a one central just desk for receiving all the papers of that department. Entire commissioner ports and other divisions and other commissioners as well. It has been served there. Entire custom house has one Shebuttam. So sending the file takes.
Kindly see at the bottom of that document, bottom of that notice. You find another stamp there.
The Chief Commissioner of Customs.
Correct. Correct. So it is not so simple, madam. Then you have to issue. Then you tell me that the documents ought not to be served there at Sevottam. I need to understand.
It can be served, but 3 working days at least takes time. For
3 working days. When have you served it? Today we are on
22nd of.
more than a month, madam. Not 3 working days, madam. More than a month is there. I'll call for this officer who is instructing you. He has to come here. Because because at the end of the day, the court's time is being consumed in this fashion unnecessarily because your officer is not assisting you properly in making available the copy of the document. There is no instruction available with you as of today. Even after a month, there is no instruction with you. I'm certain because you say that you don't have the papers. How can there be an instruction? Nobody bothers. So who is this person concerned? Then I'll call him here. This is enough.
Kindly allow me.
Yes, I will hear you. Mr. Mehta, I'll keep it after the vacation. There is no urgency in your matter. Let the gentleman come. Yes.
For my submission,
Yes. What is your submission, madam?
been having.
Yes.
It's a short passport.
Yes, Passover is there. We are hearing the matter for 15 minutes. What will you do with the Passover? Matter has been taken up in the first call.
I can take out some points.
I am waiting for you, madam. Kindly supply her with the copy here and now. I am waiting. Wait karo.
That is enough. 3 lines.
Wait, Mr. Mehta. এই আর কোনো ফাইল আছে, কাগজ আছে, আরেকটা সেট দাও তো। এই তো আছে, দাও। এটা একই ম্যাম, সেকেন্ড বলেন। Which page is the final assessment order? Page 79.
मेरा प्लीज देना तेरा।
No, this cannot be possible. Both of you will be sharing one brief.
No, I am giving him extra. I'm giving extra brief to my learned friend.
No, this is not, you will get ready in matters in court. This is not the only isolated occasion, madam. This has been happening for a while now. No, this is not happening. This is get each and every matter where you are there, more or less. I find that either you are not ready. On one of the occasions, you made submissions which you had to recall on the next occasion by saying that you did not have appropriate instructions. This is not the first time which is happening here. So you know instructions being afforded to you. So let the court assist you. Let the court find out who is the officer concerned, who is not giving you the information. Why is the not instructions percolating to you? The officer has to come. This cannot continue in this fashion. The department will be suffering. Absolutely. Because you cannot assist in this fashion. Today, Miss Mukherjee, learned advocate, appearing has happened.
Prejudice is for our.
Naturally, but department will be suffering. The department will be suffering at the end of the day. Yes, next, call the next matter.
Item number 5.
Yes.
My lord, I am appearing in the matter, but my video is not. Now it has started. Yes.
Yes, Mr. Agarwal.
My lord, in this case, I had tried to avail the benefit of Vivad se Vivad scheme.
Yes.
My lord, the requirement for availing the Vivad se Vivad scheme is that there has to be some appeal pending before some authority, my lord.
Yes.
My lord, I had filed appeal against the assessment order dated 31st of December 2015 before the first appellate authority online in 2016 itself. That papers are at page number 17, my lord.
Yes.
And acknowledgement has also been generated. At page 17 is the acknowledgement, which gives the acknowledgement number also.
Yes.
But thereafter, my lord, we had filed a grievance.
Appeal from an order passed under section 143 or 147?
143.3, my lord.
143.3. Yes.
Then, my lord, we found that in the portal, it is not showing the status that it is pending. Therefore, there is a grievance portion in the portal wherein we complained that, see, we have filed the appeal and this is the acknowledgement number, but the pendency of appeal is not being reflected. That grievance, my lord, that is at page number 25, the contents of my grievance.
Yes.
Thereafter, my lord, nothing happened and we filed form number 1 under Vivad se Vivad scheme, and the acknowledgement generated is at page number 28.
Yes. 28, I've found it. Yes. Yes. Strategy. Where, which page? Which page? Page number 47? No, where it is rejection? Where is rejection? Very well. Now, where is the scheme? Where is the scheme? Yes, Mr. Bhattacharya, Vijay Singh.
Page 49 is not available to my petition, but my lord, I have taken instruction. My lord, the department says, may I read out, my lord,
Yes.
the SSC has claimed that its case is pending before appeal, but on search of appeal pending status in instant case, nothing found available in the system.
Mr. Bhattacharya, this is what is reflected here. What Mr. Agarwal is trying to suggest here, submit here, is A, that he has an appeal which is pending. He has disclosed the receipt. He has also stated that he has lodged a grievance that his appeal was not taken up for consideration. Now, and that in the pendency status, it is not showing. Simply because in the status, it is not showing that it is not pending, that does not make it disposed of, unless it is actually disposed of. Take instructions on this. If it has been disposed of, nothing remains. If it is pending, get the benefit of the order. Simple as that. Challenging.
Mr. A copy of the fresh petition will be given to you.
Yes. Mr. At the very outset, Mr. Bhattacharya, learned advocate representing the respondents, would submit that he has not been favored with page numbers 49 to.
I have only page number 45.
page number 46 to 51 of the petition. Having regard thereto, I direct the petitioner to supply the copy of the page numbers 46 to 51 of the petition to Mr. Bhattacharya, learned advocate representing the respondents. Full stop. Mr. Agarwal, learned advocate, appearing in support of the writ petition. Forget it. The petitioner is aggrieved by the rejection of its application under Vivad se Vishwas. What is the Vivad se? What is the language? No, I have to quote the language. Just a minute.
Tax, direct tax, Vivad se Vivad.
Tax Vivad se Vishwas
Page 29, my lord.
Court. Rejection of the petitioner's application under the direct tax Vivad se Vishwas scheme 2024 video communication dated 27th January 2025. Full stop paragraph. Mr. Agarwal, learned advocate, appearing in support of the writ petition by drawing attention of this court to the acknowledgement issued by the department, would submit that being aggrieved by an order passed under section 143 within bracket 3 of the Income Tax Act 1961 for the assessment year 2016, for the assessment year 2013. 2013, only 2013 it is written. So
that is their system, my lord. Page 20, assessment year is 13-14.
Very well. For the assessment year 13-14, the petitioner had preferred an appeal. Full stop. According to Mr. Agarwal, according to the petitioner, the aforesaid appeal was not, since the aforesaid appeal was not disposed of. However, in the status since the status was showing within inverted comma open close in mode CLOACD closed, a grievance was lodged by the petitioner on 26 February 2024. Full stop. Subsequently, on 11 November 2024, having regard to the pendency of the aforesaid appeal, the petitioner applied under Rule 4 of the Vivad se Vishwas, had applied under the Vivad se Vishwas scheme 2024. Full stop. Mr. Agarwal would submit that the respondents had purported to dismiss the petitioner's appeal mechanically by proceeding on the premise, by relying on the status of the petitioner's appeal as closed, though in fact the appeal was yet to be adjudicated. Mr. Bhattacharya, learned advocate, who appears on behalf of the respondents, is directed to take instructions in the matter, list this matter in the month list of June 2024. Next.
Deeply obliged.
এই ওপরে না প্রথমে মিস্টার আগরওয়াল, লার্নেড অ্যাডভোকেট রিপ্রেজেন্টিং দ্য পিটিশনার, প্রথমটায় তারপরে তো মিস্টার আগরওয়াল। ইয়েস, Mr. Bhattacharya, you just find out that whether actually it has been disposed of or not. Means don't go by that status. Status may be incorrect because that is his case.
If the appeal is pending, he will get the
They get the benefit of it. Yes, yes.
If it's actually disposed of, your lordship, I should get some opportunity.
No. He will find out. He'll ascertain. If an order has been passed,
I did not get the order.
that is a different issue. Let him come out.
Nothing.
Let him come up with that.
Your lordship.
Yes, sir.
Deeply obliged.
বন্ধ করো না ফাজকে, এখনো দেয়নি অর্ডারটা, নামটা দিয়ে ছাপতে হবে। Mr. Banerjee, the name has to be there in that other matter, name of the officer. Otherwise, that cannot be uploaded. Find out kindly, because this will only endure to your benefit, because this has been happening in various matters I have been seeing. And the department is unless served. Ensure the name comes earlier so that I'll sign it because it has to be uploaded. Without being uploaded, I cannot call for it. Yes. Yes, yes. Which page is the order? Show cause, first show me the show cause. Did you respond to the show cause? Where is your response? Where have you stated that you have not been given any opportunity of hearing? Which paragraph? But you were never responded to with regard to that letter. No. You had by a response indicated that you had not been supplied with the, you relied on documents, you were not supplied with, they were not available on the file. Where is that letter of yours? That letter starts at page 158. It must have indicated in the same letter. Which paragraph? I see. So they supplied it ultimately. Page 146. Yes. And they have supplied it when? Where do I find it? No, that 146 is okay. 148. And ultimately 157 they send it. Yes. Yes. When was the last date of hearing? Page 151. It is recorded.
they say, as a great call, they extend the time to submit the reply. You also grants me again. And for me again. Now, my lord, I submit the.
No, 151, you see, please refer to the PH hearing today in the matter wherein requested for the RUDs of the case. Accordingly, please find the RUDs as an attachment to this email. Remaining RUDs sent separately. This is 8th November. I understand very well. So what happened thereafter? Any hearing took place after 8th? When? I see, I get it. Now what happened thereafter? Yes, where is that adjudication order? Acha, you have shown me that previously. Yes, Mr. De. Supporting paragraphs must are there.
I also got the we are saying we are not bothered with the reply and got the package report. It's no 16th of November.
Where is the 141 order? What does it say? Order does what it say? And thereafter, so-called reply was also received. Also received. In the order,
So the next item and the other question. Well, he's saying that so-called but so far as I'm concerned, in paragraph 38, we're on page 138, just above one.
Yes.
Just above one. And even after that, for 6 months, and even after 6 months, it appears nothing.
Yes, Mr. De, I have seen that. Mr. De, what is your instruction on this? I accept it. I am on not on this. I am on two other aspects also. You see, RUDs were supplied. The relied on documents were supplied only after 8th. Correct? 13th, he acknowledges that. Correct? Where is your notice offering him personal hearing after that? Did you offer him any personal hearing? Assuming, I take it that he has not responded. Assuming. Because before the RUD, you rely on certain documents. Before giving him certain documents, you could not have decided the cause. So you supplied him with the documents, you sat tight with the letter, and thereafter, only after the hearing continued, was the hearing proceeded, that is on 8th. And he raised this objection that you said that I'll supply you with the document. You supplied him the documents, your letter is there. 9th letter is there. 8th letter, 9th letter. And ultimately on his letter is, he acknowledges that on 11th. He acknowledged that on 11th. Correct. Now this order is dated. The order is dated 26 December. So 26 December, you decide the whole issue. Now you must have therefore offered him an opportunity of hearing thereafter. If you say that there may be a dispute today, prima facie that till such time you take instructions, although you need to file it by an affidavit, but there are certain aspects which require consideration in this matter. Yes, do file it on this issue. Because if he ultimately did not file any response, then the matter may be considered on a different aspect. No, for that I have to give him opportunity to respond to this. Today I cannot decide this issue. Yeah. Oh, you tell me, sir. You tell me. So RUT, the date RUT was supplied, issuance of show cause was complete, not prior thereto. At least if he does not respond also, here I have right to explain. Bring the records. You bring the records. And don't enforce the order in the meantime. Are you taking any steps to enforce it? No. Correct. So are you enforcing it? How can it be enforced? Ashu. Challenging. But those are different. Who? No, in those matters, he has considered the reply. No personal hearing was given. Yes, Mr. You are for the one, you are not different. Yes. I'll direct you. Since affidavit of service একটা একটা করে করবে, আলাদা অর্ডার হবে, সবকটাই আলাদা অর্ডার হবে। No, that is all right. I understand. Did they serve you in the same manner? He relied on documents in course of hearing 8. Where? Yes, correct. Where? Show me that. That is the relevant document. No, 148 is different. Which matter? 279. 279, WPO 279. He acknowledges that he had served. Yes, show me that. They kindly check. Wait, I'll hear you. Individually read matters. 140 at the top, yes. In terms of record of
second petition.
yes, 140, I don't get it. Yeah, it's all right. There is an internal page of the order, of your letter. Radhika Exim Limited, Private Limited. No, Raida Exim. The internal page, you see 008, 009 on the top. Yes, 123. Yes.
He had sent it by speed post and also by email. So email they must have got it, but they say no. So the same email in which they had sent the reply upon the
Very well.
so that also
Where, which paragraph? Statement. In this case, it's statement. Show me the statement, petition. Which paragraph you have said so? No hearing has been granted. Hey, Yesho. Sure. Mr. De, One more matter. How many matters are there? But I have to check up each and every matter. No, you have to show me that is actually there. Otherwise, I'm not going to pass anyone. Yes, yes. Page, sir, page. Okay. Take your time. Mr. Gorai, you ought to have prepared a small list of dates. It would have assisted. Page. And from the order also. Yes. Show me from the order. Very well. Which page? Page 123. 40.2. Very well. I've got it. Yes. And page 130, I've got it. Page 130 is your response. Yes. Dui, teen, char. Same order, Mr. Odero appointment regularized. Yes. Next. Show me that page. Arrect touch. One more. Arrect touch. Up to 10.
9.
Over. 9 is over. This was 9. Yes. No, it's all right. Password, I'll take it after I come back. 1:30. Call the list.
SS, my lord, of the Income Tax Act. My lord, the only point here, my lord, is, my lord, it is, my lord, a proceeding, my lord, which is, my lord, singularly lacking, my lord, in jurisdiction, my lord, which had been initiated. So therefore, the order also, my lord, has to go.
You are there. No. Are you appearing? Yes.
Now, my lord, may I, my lord, also warn your lordship, my lord. List, my lord, there is, my lord, item 10, my lord, there are 15 matters, but they are all over, my lord.
Then it was pointed out.
10, 12, my lord, 10, 12 to, my lord, 16.
But unless it is on a point of law, each individual matters have to be.
It's a point of law only, my lord. It is complete question of law, my lord. I have no problem, my lord. My lord, I'll tell you.
Otherwise, I have to examine each and every matter.
Correct. That's why, my lord, We saw what was happening.
You
My
see,
lord, so-
you see today,
No, your lordship's right.
10 to 35.
not that I do not, I have full confidence on my officers, but still then at the end of the day, because it will be difficult, it will not be uploaded, it will come back to the court once again for to be mentioned.
Yes.
So that will not help anyone.
10 to 35, except 11 and 30.
11, 13, very well.
Yeah.
You kindly show me only on one matter.
Yes,
Otherwise,
I'm
it
doing
will be
10.
very confusing to see.
Only 10, my lord. I am receiving the brief today. I am having the brief item number 10. I am ready with the matter in item number 10. Except item number 10, Lord, I do not have the briefs. Last
We've
let him place 10.
We have affidavit of service.
Lord, item number 10 can be, my lord, done today because it will follow, my lord. It will follow every matter.
Correct. So 10, let it be done.
Yes. Now, my lord, my lord, kindly, my lord, take, my lord, the show cause notice here.
Yes.
That's, my lord, the first document, my lord, I wish to show your lordship. At page, my lord, 227.
Page
227, my lord. My lord, 4th of January, my lord, 2025. My lord, this is, my lord, kindly have a look. Notice under section 274, read with section 271D of the Income Tax Act.
yes.
Now, my lord, the basic, my lord, point, my lord, kindly come to paragraph 8. My lord, para 8 at 237.
Oh, paragraph 8 of this notice.
Yes.
I see.
My lord, it's at page 237.
Yes.
My lord, kindly see transactions.
Now, what is this notice for? I need to know that.
Yes,
first.
my
It will
lord.
be easier for me.
My lord,
274 is?
my lord, this is for the purposes of imposing penalty, my lord, for, my lord, violation of section 269 SS. My lord, para 9 will make it clear, my lord. Kindly
Very
have a
well,
look.
very well, very
My
well.
lord, transactions discussed here and above from para 7 to 7.6.6 are tabulated below for your ready reference. My lord, kindly see the headings. My lord, it will become clear. Amount of cash loan taken in contravention of 269 SS of Income Tax Act 1961. Date of transaction, para reference number. My lord, there's a limit, my lord, as to, my lord, cash loans that can be taken, my lord, in, my lord, a particular financial year. That is, my lord, the violation which is being complained of, that you have taken in excess of the limit. And the financial years, my lord, are indicated, my lord,
Yes.
indicated here. The perusal of the transactions discussed here and above from para 7 to 8 make it clear that you have taken cash loan amounting to so-and-so in contravention of section 269 SS. You are therefore requested to show cause as to why a penalty amount amounting to 73,81,651, being a sum equal to the amount of the loan or deposit so taken, should not be imposed on you. Your reply to. My lord, this is, my lord, and my lord, I'll show your lordship, my lord, section 269 SS.
Yes.
My lord, kindly have a look. My lord, mode of taking or accepting certain loans, deposits, and specified sum. No person shall take or accept from any other person, hereinafter referred to as the depositor, any loan or deposit or any specified sum, otherwise than by an account pay check or account pay bank draft or use of electronic clearing system through a bank account or through such other electronic mode as may be prescribed, if the amount of such loan or deposit or specified sum or the aggregate amount of such loan, deposit and specified sum, or on the date of taking or accepting such loan or deposit or specify any loan or deposit or specified sum taken or accepted earlier by such person from the depositor is remaining unpaid, whether repayment has fallen due or not, the amount of the aggregate amount remaining unpaid, or the amount or the aggregate amount referred to in clause A together with amount of aggregate amount referred to in clause B is 20,000 rupees or more. So, my lord, other than, my lord, these modes of, my lord, taking loan, my lord, for a financial year, My lord, you cannot exceed 20,000. Basically, no cash loans, my lord, above, my lord, 20,000. So, my lord, if your books show that you have taken loans, my lord, in excess of 20,000, then, my lord, this is, my lord, the penalty, my lord, provision, my lord, which is, my lord, provided here. This is kindly take, my lord, section,
Transparency.
whatever, my lord. My lord, in fact, my lord, this provision, my lord, came in, my lord,
2015.
my lord, prior to that, there was also there,
Yes.
my lord, there was, my lord, I think it was my lord, more simple, my lord, as we go, my lord, over time, my lord, there are additions to, my lord, the old sections, my lord, which make it, but by and large, my lord, this is, my lord, what, my lord, the situation, my lord, was. Now, my lord, this is, my lord, the penalty, my lord, show cause notice. Now, kindly have a look at, my lord, the reply, my lord, which we, my lord, issued. Wait, no, let me find it here so that I at least have control over it. Yes, my lord, kindly come to, my lord, page 239, the reply, my lord. We take, my lord, the jurisdictional objection, my lord, straight away. 239.
Yes.
My lord, kindly see. My lord, paragraph 1, 2, my lord, and 3. Then ওটা কোথায় গেল আরেকটা reply ছিল my lord, kindly see clause 2, my lord, of this. In this connection, we would further like to submit that we have filed a petition on 22nd January 2025 before your good self, requesting to provide, my lord, kindly note this one, certified copy of the order sheet, reason, satisfaction for issuing such notice. Copy enclosed. We have also filed petitions before the learned assessing officer requesting him to provide certified copy of the order sheet from the initiation of the assessment proceedings to till date in the case of so-and-so and so-and-so. We have not yet been provided the same. Since you had provided the SSC another opportunity, we are submitting our interim reply. You are requested to allow us to make further reply on receipt of certified copy of order sheets from assessing officer and certified copy of order sheet stroke satisfaction from your office for issuing penalty notice. Now, my lord, the most important point, my lord, which is, my lord, here, my lord, the assessment order, my lord, has to record, my lord, a satisfaction, my lord, of violation of 269 SS and for proceedings to be taken. Now, my lord, kindly
Independent of that, no independent
No, it
proceedings
cannot. My lord, the Supreme Court, my lord, after which, my lord, it's been followed, my lord, by several high courts. My lord, Supreme Court decision, my lord, is there. I'll show you, lord. And circular is binding on them, but not on the court. My lord, their circular also says that, but my lord, that's binding on them, but my lord, not necessarily on the court.
Circular issued by the CBDT.
Yes, yes. But my lord, my lord, one by one, I'm just showing your lordship, my lord.
Justice Banerjee, Indira Banerjee had held CBDT circulars are binding and can be enforced also.
Correct.
Income tax matters.
Correct. My lord, one view at times which is taken, my lord, where there are opinions.
Yes.
Then, my lord, the court takes the view, the opinion might be binding on the statutory authority, but not on the court.
SSC, yes. No, not on the SSC.
No, and therefore not on the court, my lord. Court can, my lord,
can
interpret a statutory provision and a different. But here, my lord, it's a circular, my lord, which, my lord, can be enforced against, my lord, the authority.
Department.
Now, my lord, kindly come to.
Is there any, Mr. Mukherjee, is there any legal provision that authorizes initiation of proceedings under the provisions of 271D that it requires that precondition for the same is that there has to be a recording in an order passed under section 147.
There's a Supreme Court decision.
No, apart from the
No,
decision.
no. My lord, there are several statutes where your lordships might find, my lord, particularly, my lord, in the Companies Act, my lord, the formation, my lord, of an opinion. But, my lord, I'll show your lordship, my lord, section 271.
Yes,
My lord,
just
also,
show me
my lord,
what.
kindly have a look. Agree to the fire. Kindly have a look, my lord, at 271. I know I'm coming. 271D, my lord.
D,
Yes.
Delhi or Bombay?
Delhi, my lord. My lord, kindly see if a person takes or accepts any loan or deposit or specified sum in contravention of the provisions of section 269 SS, he shall be liable to pay by way of penalty a sum equal to the amount of the loan or deposit or specified sum so taken or accepted. And, my lord, the penalty who will, my lord, impose, my lord, is there.
271.
271 capital D.
Just a minute, I did not get it. So.
My lord, in that book it might be, my lord, page 1.1376.
No, it's at a running page. I'll just find it out. Yes, I've got it. Penalty for failure to comply with the provisions of section 269 SS.
That's, my lord, what I read, my lord. If a person takes or accepts any loan or deposit or specified sum in contravention of the provisions of so and so, he shall be liable to pay by way of penalty a sum equal to the amount of the loan or deposit or specified sum so taken or accepted.
Yes.
Now, my lord, kindly have a look at their reply. My lord, I just want to complete 4 facts
Yes,
situation.
I
My
just
lord,
wanted
before
to-
I get into the issue of jurisdiction. Now, my lord, their reply, my lord, is of 7th of March 2025, page, my lord, 251. Kindly come to, my lord, page 254. My lord, paragraph 2 is what I had placed, my lord, of my lord, reply to, my lord, the show cause notice. Now, my lord, this is replying to that. My lord, they set out a paragraph 2. The SSC have stated they are not provided with the order sheet stroke reasons satisfaction for issuing notice under so and so. Lordship has that. Now, my lord, the response. In this regard, it is submitted that all the penalty proceedings initiated in the case of the SSC are being carried out through ITVA systems of the department, which is also visible to the SSC. Hence, the allegation of the SSC of not providing the order sheet does not hold ground. Now, my lord, kindly see our response. It will become clear now. My lord, that means, my lord, the portal. Now, kindly have a look, my lord, at our response, 13th of March 2025. My lord, page 261. My lord, paragraph 2. We state that in the said notice dated 7 March 2025, your good self has stated that the instant proceedings are being carried out on the ITBA systems of Income Tax Department, and the same is also visible to the SSC. However, we state that neither the order sheets as requested above nor the satisfaction note with reasons are available on the portal and as such are not visible to us. In this regard, we are annexing copies of the screenshots of the portal and the same are collectively marked. From the said screenshots, it can be seen that neither the order sheets nor the satisfaction note have been uploaded on the portal of the Income Tax Department. Now, my lord, kindly come to
265 screenshot is there.
yes.
To do the screenshot,
Yes.
sir.
Now, my lord, kindly come to, my lord, page 275, my lord. That is, my lord, another, my lord, reply, my lord, issued by us, another additional reply. Kindly come to, my lord, page 276, my lord, paragraph 2. My lord, without prejudice to the above, it is submitted that the aforesaid proceedings are bad in law and without jurisdiction, as the assessee has not in any manner whatsoever contravened so and so, and as such there is no satisfaction recorded in the assessment order dated 31st March passed in the case of the assessee for the assessment year 2016-17. We state that none of the conditions precedent for assumption of jurisdiction under 271D of the Act have been satisfied. We further state and submit that assessee has not dealt in any cash which could result in violation of so and so, and as such the proceedings ought to be initiated are bad in law and without jurisdiction. We submit, now kindly note this, that if no satisfaction is recorded in the assessment order of violation of 269 SS and or imposition of penalty under section 271D, then the penalty proceedings under section 271D are bad in law and without jurisdiction. Reliance in this regard is placed on so and so, so and so. My lord, we have, my lord, given, my lord, the case reference, and my lord, then, my lord, after this decision, there's, my lord, an Andhra Pradesh High Court division bench decision, my lord, which is, my lord, also being relied on. My lord, several decisions. And then, my lord, kindly come to 277. My lord, these are decisions which are referred to. Kindly take, my lord, the last 10 lines. My lord, left-hand side of the page. Further, it is pertinent. Your lordship has that. Further, it is pertinent to note that even circular number so and so dated April 26, the Honorable has directed the assessing officer to make reference to the range head in course of assessment proceeding. In the instant case, no such satisfaction has been recorded by the assessing officer in the assessment order that there has been a violation of 269 SS and or that penalty under proceedings under so and so should be initiated, and as such the proceedings are clearly bad in law and without jurisdiction.
Which page is the circular? This circular?
Yes, my lord, I'm just showing your lordship that, my lord.
I'll just note it here.
Yes, my lord, it is, my lord, I'll show your lordship.
Yes.
My lord, the circular, my lord, is there separately.
Oh, separate. Every minute one.
महाराज है एखाने। My lord, kindly take this circular, my lord, 26th April 2016.
Yes.
My lord, first see, my lord, it has been brought to the notice, my lord, what gave rise to this, my lord, also. It has, my lord, kindly see the subject first. Commencement of limitation for penalty proceedings under section 271D and 271E of the Income Tax Act. It has been brought to the notice of the Central Board of Direct Taxes, hereinafter referred to as the board, that they are conflicting interpretations of various high courts on the issue whether the limitation for imposition of penalty under so and so hereinafter commences at the level of the assessing officer below or at the level of the range authority, that is Joint Commissioner of Income Tax. Some high courts have held that limitation commences at the level of the authority competent to impose the penalty, that is the range head, while others have held that even though the assessing officer is not competent to impose the penalty, the limitation, now kindly note this, commences at the level of the assessing officer, where the assessing officer has issued show cause notice or referred to initiation of proceedings in the assessment order. Now, my lord, on careful examination of the board is of the view that for the sake of clarity and uniformity, the conflict needs to be resolved by way of a departmental view. The Honorable Kerala High Court, in the case of Grihalakshmi, observed that question to be considered is whether proceedings for levy of penalty are initiated with the passing of the order of assessment or by the assessing officer, or whether such proceedings have commenced with the issuance of the notice issued by the Joint Commissioner. From statutory provision, it is clear that competent authority to levy penalty being Joint Commissioner. Therefore, only the Joint Commissioner can initiate proceedings for levy of penalty. Such initiation of proceedings could not have been done by the assessing officer. The statement in the assessment order that proceedings under 271D and E are initiated is inconsequential. On the other hand, if the assessment order is taken as the initiation of penalty proceedings, such initiation is by an authority who is incompetent, and the proceedings thereafter would be proceedings without jurisdiction. If that be so, the initiation of the penalty proceedings is only with the issuance of the notice issued by the Joint Commissioner to the assessee, to which he has filed his reply. The above judgment reflects the departmental view. Accordingly, the assessing officers may be advised to make a reference to the range head. Now kindly note this. Regarding any violation of the provisions of Section 269 SS and Section 269T of the Act, as the case may be, in the course of the assessment proceedings or any other proceedings under the Act, the assessing officer shall not issue the notice in this regard. The range head will issue the penalty notice and shall dispose of complete the proceedings within the limitation prescribed under 275(1)(c). Where any High Court decides this issue contrary to the departmental view, the departmental view thereon shall not be operative in the area falling in the jurisdiction of the relevant. So, my lord, the view, departmental view, my lord, cedes, my lord, jurisdiction, quite rightly, my lord, to, my lord, the High Court, my lord, which is, my lord. So, my lord, the reference, my lord, to the range head, my lord, has to be, my lord, the assessing officer during the course, my lord, of, my lord, the assessment proceedings. The last is, my lord, the order itself. That we find this, you take steps to the range head, you may determine whether penalty proceeding should be initiated or not. Then, my lord, the range head issues the show cause, as has been done here. So, my lord, we only ask for, my lord, this, my lord, because Supreme Court has said this is a finding which has to be arrived at also. And now, my lord, this is the circular. Now, kindly see the order once. My lord, first, now, kindly, the penalty order, my lord, is of 29th March 2025, which is, my lord, P11, page 283. My lord, kindly come to, my lord, page 284. Subsequent to completion of the search assessment proceedings under section 143(3) read with 153A of the Act, the case was referred for initiation of penalty proceedings under 271D by assessing officer, namely Deputy Commissioner of Income Tax, so-and-so, Kolkata, to Additional Commissioner, Vivad reference dated 3rd January and 18th February. Now, my lord, kindly come to page 298, my lord. My lord, this is, my lord, the exact table, my lord. What? Oh, sorry, my lord, 290. First, kindly have a look at, my lord, 290. My lord, the para 8.1.6, my lord, kindly note this. However, even after being given opportunities, assessee failed to furnish any explanation so-and-so. Instead, assessee submitted a letter dated 27 January raising objections, which was rebutted with a notice dated so-and-so. For the sake of brevity, this I have placed before your lordship. Lordship would recall, my lord, paragraph 2 at page, my lord, 293, 292 bottom, 293. I'm only on jurisdiction, my lord. 292, not provided the order, the same rebuttal, my lord, is, my lord, set aside. Then, my lord, important thing is our subsequent letter, my lord, of 7th of March, my lord, is not referred to at all. Where we said it's not in the portal. What you are referring to, that there is a satisfaction recorded, my lord, it's not there in the portal. So, my lord, now kindly Oh, sorry, my lord, 20. My lord, there were two letters, 25th and 27th.
The
25th.
second letter, I remember.
Yeah. I've just placed it, my lord. That is not in the portal. What? 198.
Yes.
Now, my lord, kindly have a look, my lord, at paragraph 8.17. In response to the rebuttal dated 7th March, the assessee submitted a reply dated 13th March and 25th March, reiterating the same contentions which has already been rebutted with a notice dated 7th March. It is therefore not necessary to give another rebuttal. Now, my lord, I pause here. My lord, we had said it's not on the portal. We had given the screenshot. To that they say I've said nothing new. Which is, my lord, clearly, my lord, it did not consider, my lord, really the letters, my lord, after, my lord, the first response of 7th of March. So, my lord, now kindly have a look. Assessment order touch it. Here. Have we filed it? Given them copies, huh? My lord, kindly take the supplementary affidavit.
Supplementary.
Yes, my lord, I'll tell your lordship why. My lord, your lordship needn't look at it also. My lord, I have also got the assessment order with me. My lord, the assessment order does not record such a satisfaction.
Naturally, you will be having the order.
Yes, my lord, they
You did not disclose it here.
no, I've referred to that. It does not. My lord, that's
That is in the supplementary.
That's
I
all.
can't see that.
that's all. Nothing more. My lord. Serve করেছো তো, other side.
No statements, only the sub
Yes,
order. Yes,
yes. No, my lord, no statements at all, my lord. We have stated, my lord, that, my lord, we have, my lord,
Very well. So
page 4, my lord, is, my lord, the assessment order.
it is for him to come up and show whether
Yes,
it
my
is
lord.
there or not.
It's, my lord, not there at all.
Show me the judgment of the Supreme Court.
Yes, my lord. My lord, kindly take Jayalakshmi, my lord. Now, my lord, before your lordship looks at it, my lord, your lordship recalls, my lord, subsequent response, my lord had said, my lord, first, my lord, it's not in the portal. Second, my lord, we had also said, my lord, that, my lord, there was a circular and, my lord, there were these judgments. None of those have been considered at all. Going on two issues, my lord, your lordship's realizing, my lord, not having dealt with at all. But, my lord, most important, my lord, is, my lord, jurisdiction. Now, my lord, kindly take, my lord, this order. It's a very short order. My lord, it's just 2 pages. May I just read it, my lord? This is, my lord, of the Supreme Court. In these appeals, we are concerned with the question as to whether penalty proceeding under 271D of the Income Tax Act is, kindly note this, independent of the assessment proceeding, and the question arises for consideration in respect of so and so under the following circumstances. In respect of assessment year 1992-93, assessment order was passed on so and so on the basis of CIB information informing the defendant that assessee is engaged in large scale pursuit, but it is not filing in ex parte proceedings initiated, which resulted in as per which net taxable was assessed. While framing the assessment, the assessing officer also observed that the assessee has contravened the provisions of section 2 so and so 269 SS, and because of this, assessing officer was satisfied that penalty proceedings were to be initiated. When my lord, assessee carried out this order in appeal, the Commissioner of Income Tax allowed the appeal and set aside the assessment order with a direction to frame the assessment de novo after adequate opportunity. After remand, the assessing officer passed fresh assessment order. In this assessment order, however, kindly note, no satisfaction regarding initiation of penalty proceedings under section 271E of the Act was recorded. It so happened that on the basis of the original assessment order dated so-and-so, show cause notice was given to the assessee and it resulted in passing the penalty order dated so-and-so. Thus, this penalty order was passed before the appeal of the assessee against the original assessment order was heard and allowed, thereby setting aside the assessment order itself. It is in this background a question has arisen as to whether the penalty order which was passed on the basis of the original assessment order and when that assessment order had been set aside could still survive. The tribunal as well as the High Court has held that it could not be so for the simple reason then when the original assessment order itself was set aside, kindly note this, the satisfaction recorded therein for the purpose of initiation of penalty proceedings under section so-and-so would also not survive. This, according to us, is the correct proposition of law stated by the High Court in the impugned order. As pointed out above, insofar as fresh assessment order is concerned, there was no satisfaction recorded regarding penalty proceedings under so-and-so, though in the order the assessing officer wanted penalty proceedings to be initiated under 271C of the Act. Thus, insofar as penalty under 271E is concerned, is without any satisfaction and therefore no such penalty could be levied. These appeals are according. Now, my lord, here we are concerned with D.
So here the court was concerned whether a penalty proceedings initiated on the basis of a
lord, more-
satisfaction
Correct.
of the assessing
So
officer.
satisfaction is necessary.
That whether
Yes,
the
yes, yes.
satisfaction is necessary or not,
Yes, yes.
that
but-
is not the ratio of.
No, of course it is.
Yes,
Kindly
yes.
have a look, my lord. Kindly read
Okay,
it.
let me go back because it requires that there has to be a satisfaction.
By the assessment.
The satisfaction provided for in the section itself.
Doesn't have to be. It can be by virtue of law declared on an interpretation of the sections.
But this issue that was before the Honorable Supreme Court,
My lord-
correct? Yes. That
No,
is
no,
something-
kindly read para 4, my lord. It will become clear.
Yes, yes.
The tribunal as well as the High Court has held that it could not be so for the simple reason that when the original assessment order itself was set aside, the satisfaction recorded therein for the purpose of initiation of penalty proceeding would also not survive. This, according to us, is the correct proposition of law stated by the High Court in the impugned order. Then, as pointed out above, insofar as fresh assessment order is concerned, there was no satisfaction recorded regarding penalty proceeding under section 271E of the Act. Though in that order, the assessing officer wanted penalty, this is the fresh one, penalty proceedings to be initiated under 271C. Thus, insofar as penalty under 271E is concerned, it was without any satisfaction and therefore no such penalty could be levied. There has to be satisfaction of penalty, my lord, being imposed.
Just a minute.
I'm sorry.
Yes, go.
তোমার satisfaction. Correct. Satisfied. এখানে বললো ঠিক আছে 271C is recorded satisfaction, that's fine. but এটা হতে পারবে না, similarly D. Correct. Correct. So first এখানে satisfaction ছিল 271(1)(c) has conceived particulars. And then if any amount is allowed, there's a
আমি জানবো কেউ না আপনি having regard thereto and having a consent officer is Rajiv Kumar Meena is a to be person who had been instructing Ms. Mukherjee to be personally present today at 2 p.m. before this court to explain his argument. The instructions are not being included in the argument. And she will be picking up today at 2 p.m. এটা একটু করে দাও, এখানে করে দাও না, এখানে করে দাও, সই করে দাও, আবার উপরে যাবে আসবে। Yes, 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 sorry.
yes. Now, my lord, kindly come to. So, your lordship sees, my lord, paragraph 5 clearly records, my lord, the assessment order. My lord, there were penalty proceedings to be provided satisfaction that 271(c) should be initiated, but did not provide for 271(e). And my lord, it says, thus, insofar as penalty is, it is without any satisfaction, and therefore no such penalty could be levied. So, my lord, ratio is, my lord, not.
It does say so.
Yes.
It does say so. Though initially the court was not concerned with that, but ultimately the court observation
I'll
made
tell
by
you-
the court is binding.
My lord, I'll tell your lordship, my lord, court had to be concerned because what was the argument by the revenue? The argument by the revenue was, so what if the original assessment order has gone? We have conducted a penalty proceeding and found that there is penalty should be levied under 271(e).
To that the Supreme Court said there has to be satisfaction.
Because the original,
the
my lord,
subsequent order did not record.
correct, my lord. So if it did, my lord, then that proceeding would have gone through. There was actually no assessment order in place on the date of imposition of penalty, my lord, saying, my lord, that there was a satisfaction recorded.
This is your case.
My lord, this is in short. Now, my lord, I want to show your lordship. My lord,
Today, final
no,
hearing.
no,
and
no, no. My lord, your lordship put a query. My lord,
yes, yes. Now let me hear from him. You are
because there's
here.
no express provision, my lord, etc.
No,
my
there
lord,
is
I
no.
can deal.
So there is no.
No, I can deal with that because, my lord, the act itself.
No, unless you
My lord, I
want me
don't-
to decide it
No,
today,
no,
I
no,
can
no.
decide it.
No, no,
But today unnecessarily.
no, my lord, I want, my lord, an interim relief.
I understand. I'll
My
hear
lord,
from
because recovery proceedings can be started, my lord, because, my lord, after penalty is being imposed, my lord, recovery proceedings, my lord, can be started.
very short point. Let me understand. But you have the assessment order. According to you, there is nothing
No, no,
as such in the assessment.
No, nothing of 269 SS, my lord, there's no satisfaction.
Yes, Mr. Bhattacharya.
My lord, deepest respect, my lord.
I did not want to stop you here, Mr. Mukherjee, but
I submit
short.
that-
This is a short point, so yes.
My lord, this is a order of the Honorable Supreme Court. My lord, it is culminated to assessment order to CIT appeal, ITAT Supreme Court. Now, my lord, here order as under section 271D has been passed. There is a provision for statutory appeal. The statutory appeal provision has not been availed by the assessee. My lord, he has come.
I couldn't follow you, Mr. Bhattacharya. Come again.
But it is from this order, from this impugned order under section 271D, there is a provision of statutory appeal.
Yes.
Now, that the
That is your only defense.
no,
Yes. You answer me,
defense-
and that defense is always there to you.
that defense is Milord strong defense, because Milord the assessee cannot open the floodgate. 271 proceedings is a separate proceeding, assessment proceedings is a separate proceedings, penalty proceedings is a separate proceedings. From the assessment proceedings, statutory appeal is there. From the penalty proceedings, statutory appeal is there. Now, Milord, if the assessee want to choose to come this writ court under Milord Article 226 Constitution of India, Milord, when the court use the discretionary power, Milord, he has to satisfy Milord 4 conditions. Milord, I am relying some judgment to this regard, Milord.
No, what you just first of all, I want to clarify the law on the subject also. 271E does not
But there is a
make any provision.
271E cash loan, D cash receipt.
Correct.
But section
That
has
part
said-
is okay. Whether the satisfaction is necessary, answer on that and then show me whatever judgments you want to.
But my respectful submission, satisfaction is not necessary.
Not necessary. Anything on that?
But I am coming. But I am
Yes, yes, yes.
that my lord.
My lord, to assist my learned friend, my lord, I just want to give, my
Yes.
lord, that satisfaction directly on this issue, my lord, is necessary. There's an Andhra Pradesh High Court after
Yes,
Supreme
that
Court.
was relied on
division
in that.
bench. Yes.
The
Yeah,
judgment,
my learned
This is
friend.
167
This
tax.
was a writ petition.
my lord, the
No,
my lord, circular relied by my lord, learned senior friend, my lord, says my lord, one judgment of the my lord, Kerala High Court. My lord, I also place this judgment of the Kerala High Court. What the Kerala High Court says, thereafter my lord, circular relied by my learned senior friend. Now, before that, my lord, for coming this my lord, writ court, the writ petitioner has to my lord, satisfy to your lordship. There is my lord, 4 criteria that my lord, the patent violation of natural justice, he has not given the opportunity. My lord, your lordship has seen. My lord, he has given the show cause notice. Thereafter, my lord, he has given some reply saying that some portion of the order to be given. We have said, my lord, that is in the portal. The portal says, my lord, I also saw the portal says there is a portion upload notice and on views in the portal which my learned senior friend.
show me from the portal. I will accept it. Any reference to the satisfaction.
No,
Matter will come to an end there and then.
Satisfaction is not required.
So no, irrespective, do not go to the portal. I will not rely on that.
Then, Milord, my first submission, Milord, he has not come.
Fundamental issue, what Mr. Mukherjee just indicating, what I've understood from Mr. Mukherjee's submission, the fundamental issue that what Mr. Mukherjee has raised here in this petition is that though the proceedings are independent proceedings under section 271, but there has to be a basis for initiating such proceedings, and the basis is the jurisdiction can be assumed provided there is a finding in this regard in the assessment order. That is what his submission is.
My submission.
That is his submission. Now you
my
answer this.
submission to this respect is that, Milord, the assessment proceedings, that is a separate proceeding. The assessing officer itself has no power to issue, Milord, the show cause notice. Your lordship.
Correct.
Then therefore his satisfaction also not required. Milord, may I?
Yes, I will hear you on this. I want you to submit on this.
One by one, Milord.
Yes,
Now,
slowly. You take your time.
The Milord, in the petition, paragraph number 29, the writ petition's case has been made out. This is the writ petition's case. Milord, your lordship sees paragraph number 29 of the writ petition. But this is, Milord, altogether, Milord, what I subject to lordship correction and what my learned senior friend says, Milord. This is his, Milord, submission altogether.
This is summed up here. Absolutely.
Yes. Now, before going to this answer to these issues, Milord, I want to place some judgment regarding the, Milord, the writ petitioner should not come this court. Now, this is a, Milord, constitutional bench judgment. Sir. Now, Milord, this first paragraph.
Yes.
These appeals has been filed with the certificate granted by the High Court of Assam under Article 132 of the Constitution of India, order passing certain petition filed by the appellant praying for writs of certiorari or other appropriate writs, quashing order relating to assessment of sale tax, and prohibiting the superintendent of taxes, Dhubri, and other officers from taking action in enforcement of the said order. The appeals raise common question that may be disposed of by the common judgment. Now you will also kindly see paragraph number 7 and 11.
Yes.
But I am skipping without 1, 2, 3, 4, 5, 6, 7, 8 line. The jurisdiction of the High Court.
I've got it. Please.
The lordship got it.
Yes.
But the jurisdiction of the High Court under 226 of Constitution of India is cast in
Couched.
wide terms,
Yes.
and the exercise thereof is not subject to any restriction except the territorial jurisdiction which are expressly provided in the articles. But the exercise of this jurisdiction is discretionary. It is not exercised merely because it is lawful to do so. The very amplitude of the jurisdiction demands that it will ordinarily be exercised subject to certain self-imposed limitations. Resort that jurisdiction is not intended as an alternative remedy for relief which may be obtained in a suit or other mode prescribed by the statute. But I am emphasizing this, my lord. Ordinarily, the court will not entertain a petition for a writ under Article 226, where the petitioner has an alternative remedy, which, without being unduly, provides an equally efficacious remedy. Again, the High Court does not generally enter upon a determination of the question which demand an elaborate examination of evidence to establish the right enforced which is writ is claimed. Not here the question of examination of evidence is there. Not the satisfaction note. Even I say it is not required. But here the question of examination of evidence there, that
Only
can
examination of evidence or elaborate examination?
be elaborate examination. That can be purposely will be done by the man of CIT appeal.
Yes. Next, Mr.
The writ court does not therefore act as a court of appeal against the decision of a court or tribunal to correct error or fact, or does not by assuming jurisdiction under section 226 takes upon the alternative remedy provided by the statute for obtaining relief. Where it is open to the aggrieved petitioner to move another tribunal or even itself in another jurisdiction for obtaining redress in the manner provided by a statute, the High Court normally will not permit by entertaining a petition under 226 Constitution. The machinery created under the statute to be bypassed and will leave the party applying to seek resort to machinery to set up. Now, paragraph number 11.
No, 12. Directly, we accordingly decline. The reasons have been given. Why?
We accordingly decline to entertain the applications. Our raised question as well. You have lordship read out.
Yes.
For me, your lordship read out.
No. Ari, you are showing me this. This is it. This is the reason.
Yes.
First of all, it was not conferred before the appropriate authority. Not the case here.
And only one line,
Yes.
the paragraph number 11.
Yes.
It was open to them to resort to the machinery provided by the Act, and having failed to do so, they could not ask the High Court to act as an appellate authority in clear violation of statutory provision and to bypass the machinery provided by the Act.
Yes. Just a minute, sir. Just a minute. Because, no, that you give. But
Then my lord, I will not place this judgment. I will place my lord another judgment. It is necessary.
yes, whichever. You don't multiply. The issue is. If it is on the same point,
But it's required some my lord.
absolutely. Give me.
The amendment of the Income Tax Act itself.
Yes.
Now, your lordship, kindly see the my lord state my lord paragraph number my lord 11. This is the submission of the my lord the parties. My lord, this says that my lord the petition should not be entertained in my lord 148 AD stage.
No, what was the fact or what was the challenge?
Fact, my lord, the in 148 proceedings, my lord, the petitioner come before the my lord writ court. The fact of the assess is a Sikkim board non.
This was a pre-2010, 2021. Pre-2021.
Principle is just same.
No, I'm just asking.
Yes.
Pre-2021. Where is the scope to challenge your 148 notice in an appeal?
In that stage, my lord, before issuing the 148 notice, the assessing officer is required to give the my lord reason recorded to the my lord assessee.
Then
My lord, it has now come
148 A, B, and then D order.
148B, we are giving reason. In that point of time, 148AB not there. Therefore, the assessing officer is supposed to give the reason for issuing 148 notice.
In the state of Sikkim. Only.
No.
Throughout the territory. Very well.
Now, your lordship, kindly see the paragraph number 16.
Yes.
16, 17, my lord, 16, 17. But may I read out Placidum
19, actually 19, the answer is complete machinery for assessment of tax, imposition of penalty.
paragraph number 13, my lord. Referring the judgment of the Honorable Supreme Court, my lord, second paragraph. This is, my lord, something, my lord, very important.
Yeah, the High Court did not give any reasons for invoking the extraordinary remedy.
But these Honorable Supreme Court, following the judgment of the earlier Honorable Supreme Court, you will kindly see paragraph number 13.
Yes.
In Titagore paper mills case, such and such, the court observed such and such. It is now well recognized that where a right or liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by the statute only must be availed of. The rule was started with great clarity by Wilson.
Which paragraph you are placing?
Paragraph number 13. No, not paragraph number 13. After 17, my lord, paragraph number internal classicidum, that is, my lord, page.
Your Nivedita Sharma's case.
Titagore paper mills case. Titagore paper.
Paragraph 17 is.
Thereafter, next page, my lord, next page.
Acha. In Nivedita Sharma's case, while this court considers
Yes.
this judgment,
Malad, now
Titagarh Mills, yes.
important, Milord, Titagarh Paper Mills Company Limited, Milord. It is now well recognized where a right or liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by the statute only must be availed of. The rule was started with a great clarity by with J such and such. There are three classes of cases in which a liability must be established founded upon a statute.
Mr. Bhattacharya, to establish this as a proposition, a complete proposition, you have to place Titagarh Mills case. Otherwise, it will be picking and choosing. You see, in this judgment of Nivedita Sharma considers this, and quotation is there. Only a part of that judgment is there. Show me the entire judgment of Titagarh Mills case in that case. Titagarh Paper Mills case, I'll consider what has been said there. The ratio of this judgment you have to gather from this judgment, not with the reference to some other judgment.
Then, Milord, you will have to kindly see paragraph 19.
Yes,
This judgment.
correct.
Thus, while it can be said that court has recognized some exception to the rule of alternative remedy, why the statutory authorities has not acted in accordance with the provision of the enactment in question or defiance of the fundamental principle of judicial procedure, or has resorted to invoke the provision which were repealed, or when an order has been passed in total violation of principle of natural justice, the proposition laid down in such and such. And other similar judgment that High Court will not entertain a petition under Article 2 Constitution if an alternative requires remedies available to a every person. That is not some of the judgment. But if your lordship allow me, place one judgment, I have forgotten to print out this, only one portion.
Always.
Kindly give me 1 minute.
Yes. Just share the citation with the other side and with me.
Yes. But this is 1998 8 SCC 1.
Whirlpool. Yes, place it. Yeah, he'll be relying naturally. Yes, which paragraph?
Yes, I'm just
1998, 1 SCC 1.
8 SCC.
8 SCC 1.
8
8 SCC 1. Yes.
Lord, I can assist your lordship, my lord, with the case so that my lord,
Yes.
my learned friend can read.
And the Honorable Supreme Court has specified, Milord, right there have been laid down by the Supreme Court. Kindly give me your 1 minute, my lord. Paragraph number 15.
20, you read 20 also. Much water has since flown under the bridge.
15, my lord.
No
Very
corrosive effect.
Yes. Not possible. Then Mr. Bhattacharya, let me come back. It will take some time. You want to anything else? Because this is only on maintainability you are placing.
Thereafter, my lord, I will submit to your lordship, my lord, the satisfaction also is not required.
That is what I wanted to
Your
show
lordship,
me.
come back, my lord.
I'll come back. Because it cannot be completed within 1:30. And what about the original, the appellate side matters?
Then, my lord,
They
it is
go.
not your lordship, not saying that it is now my lord one matter, but benefit will be 24 matters. My lord.
Maybe, but what about the appellate side matters? You see what happens after the recess, what happens there. But before anything, I will just, since the, very well, I'll take up complete this and I'll let the officer wait. After that, I'll take it up. কন্টিনিউ চলছে।
regarding now you should kindly come to the departmental circular that has placed paragraph number 4. By submission to the lordship, assessment proceedings and the penalty proceedings is not two separate issues. But even the assessing officer has no power, admitted. Assessing officer has no power to issue by commissioner level.
Without any assessment order, a penalty proceedings can be initiated.
But the proceedings are separate and your
Naturally separate.
application your assessment order.
Like determination of mean profit is always a separate proceedings. But unless there is at the very first instance, there is a decree determination question or doesn't arise.
But why I am submitting the assessment case? The admission has to be made regarding to
Show me that very well. That I have understood. This is a separate, Mr. Bhattacharya. That part I have understood. This is separate. Show me that there is any reference in the order, assessment order, with regard to 271D and with regard to non-compliance of 269 SS.
not there.
Not there. Admitted. No, I asked. Just admitted. Naturally.
I cannot read the record. Now that your lordship kindly see your paragraph number 4. Now, one thing your lordship also realize. This point in my
If I don't go into this para 4 also of the CBDT circular, what do you have to do, say to the Supreme Court judgment? Show me the Supreme Court judgment. Place that Supreme Court judgment. Distinguish that.
This is not after the CIK appeal. CIK appeal can not adjudicate the issue.
Achha, so do that. So you say that maybe it is not there, but this court should not decide it. This matter should be decided.
Evidence.
Evidence.
Yes.
So you say it is not there. What evidence is there?
But these thereafter why will I am placing the paragraph number 4? There is a reference for CIK.
Absolutely, Mr. Bhattacharya. I have not stopped you, Mr. Bhattacharya.
In the above judgment reflects the department that I am not repeating because accordingly the assessing officer below the rank of Joint Commissioner Income Tax
বের করে দিয়ে দাও।
Income tax may be advised to make a reference. The assessing may be advised to make a reference to rate check regarding any violation of the provision 269 SS and 269P of the Act. But here the reference has been made by the assessing officer. You have to kindly see the ordinance itself.
Yes. Which paragraph are you placing, sir?
No.
Yes.
The above judgment. Yes.
You want to place the circular or the judgment?
Paragraph number 4 of this.
Yes.
The above judgment reflects the Contractual view that reflects in the judgment of the Kerala.
Yes.
Accordingly, the assessing officer below the rank of the Joint Commissioner Income Tax may be advised to make a reference to the rate check regarding any violation of the provision of 269 SS and 269P of the Act, as the case may be in the course of assessment proceeding or any other proceeding under the Act.
So therefore, the reference has to be made by the assessing officer.
In the assessment proceeding or any other subsequent
Assessing officer who is below the rank of the Joint Commissioner of Income Tax. Otherwise, he himself can initiate this.
There is no point that will be assessing officer below the rank of the Joint Commissioner. There is no point. But here the point is that the satisfaction note is not there in the assessment order.
Yes, correct. Absolutely.
That is the point, main point. My submission is that the circular itself says the in the course of assessment proceeding or any other proceeding under this act or any
Yes.
other proceedings means the proceedings under the 271D. But here now we are also kindly see the page the full order page 283 of the lordship says
This will not control the statute. This is only the CBDT circular. This is go by the judgment. Come, Mr. Bhattacharya, will let us not go into this circular. Come to directly to this judgment. Today we are, you see, pressed for time also. Come to the judgment of the Honorable Supreme Court.
Only the page 284.
I will not rely on that circular, the CBDT circular. Come to the judgment. Let us go to the judgment. Ignore that circular. That circular is binding on you.
I am following
That by not binding on me. So therefore, I may not consider it. Now, show me from the judgment of the Honorable Supreme Court, there is no requirement of satisfaction. As simple as that. Your first point remains. Your first point remains. That is an independent argument. Whether this court will entertain the matter or not. Now, assuming I accept it, matter comes to an end. Assuming I don't accept it, then you have to give a response. So what is your response to that? Is it
does not say so. But
Act does not say so.
But act itself very categorically act does not.
Very well.
But the circular itself says there should be a reference. But in that particular order, there is a reference of the assessing officer. But the proceedings start from the show cause stage, not before that.
Very well. Anything else you want to add?
Only the one judgment I like.
Yeah. Citation.
I am given the but only on another aspect because also kindly the jurisdiction kindly also think about that this is my submission. Now that this is a penalty proceedings and the from the penalty order, it is apparent that the assessee had not cooperated with the proceedings, but he had submitted repeated petition, paying adjournments, but he is not at all cooperating with the proceedings. Now, even if I say that, that there is a lacuna in the assessment order, satisfaction note is not there. Your lordship, but when we are sitting in the constitutional court, whether interfere with the penalty proceedings, when the assessee itself apparent from the record that he is not cooperating with the proceedings. But this is a court of equity. But what point my learned senior friend has taken, that is a technical point. Not act does not say so. Now
then you have to go in and explain from 271 itself. Read the entire each and a particular provision and which of the provision makes which particular provision to be taken into consideration. What 271 says, what 271 AA says, you have to place all of them. Then to find out what is the scope and ambit of 271D, which I initially asked. Let us not go into all these things today. Your only your contention, if you see today the admitted position as it stands, you admit the fact that there is a lacuna in the order. But you admit means you cannot improve upon the case. You cannot supplant by way of an affidavit also whatever is there in the order. Now, whether the assessment order makes a reference to this particular provision A, whether there is a satisfaction of the assessing officer B, are the issues for consideration. But such consideration window can only be opened according to you, provided this court accepts the challenge in exercise of its writ jurisdiction, especially when a statutory remedy has been provided therefore. Correct?
And another the CBDT circular.
CBDT circular I'll not consider. Forget it. I don't want, because today I would have considered it on a different day. Today I am not going to consider it.
Now the consequence will be order passed in 24 matter. The point of the technical point of view of the satisfaction.
You want to argue your hearts out. I will your heart's content. I will hear you on another date. Today is not the date, Mr. Bhattacharya. If I do not accept the challenge, I throw away the matter. If I throw away the matter comes to an end. But if you want to argue, I will hear out and conclude the matter, because point is very short today. Point is absolutely very short. So there is no dispute, according to you. Parties would agree that there is no satisfaction recorded. But question for consideration is whether there is any requirement of the satisfaction. Prima facie, though, from the Honorable Supreme Court's order, which you did not address at all, it would transpire that there is a requirement of satisfaction. All the matters are identical. Identical.
Absolutely. Identical in the sense without the only another submission is there. If the assessee today chosen to file the appeal before the CIT appeal, he has to put 20% of the amount. Now the writ court cannot pass the blanket order of stay in the penalty proceedings.
No, that's not a prerequisite. That's not a
Let there be a balance. Only we are saying that the satisfaction note is there. The matter go and we are the assessee.
If I do not admit, okay. If I do not admit, okay. The moment I admit with this direction, it will be immediately set aside. If I admit it with this direction.
That cannot be, Milord. The penalty proceedings, one only say that, Milord, the satisfaction note is not there. Blanketly, Milord, order of stay, Milord, I'm praying before your Lordship, kindly think about that. And your Lordship, kindly also.
Yes, Mr. Mukherjee, what do you say to this? Whatever he says, just a different point he says.
Well, there's no mandatory requirement, number one.
Yes.
Number one.
No.
And my lord,
this mandatory required.
Yes.
But discretion is always there.
No, my lord, I'm not on rate. My lord, I'm on an appeal. Also, there is no mandatory requirement.
Appeal is also mandatory.
No.
Your Lordship, kindly.
No, it is not a pre-deposit. Mr. Bhattacharya,
It's not a pre-deposit, my lord.
Kindly, your Lordship passed an order upon a petitioner to impose 10 lakhs, 10 crores.
Yes.
That is reduced to, Milord, 6 crores. It is not that the appellate court will interfere blanketly, will assessment order has been stayed. The penalty order has been stayed blanketly without giving anything to
and my lord,
let us see. I may not admit it. Yeah. Let me find out. You have argued. Yes.
My lord, only 2 minutes, my lord, I want to take.
Yes.
My lord, the only issue we raise before your lordships, my lord, is, my lord,
whether there is a satisfaction or not.
That's a question of jurisdiction. We raise it as an issue of jurisdiction. My learned friend, my lord, has cited 3 cases before your lordship. My lord, none of those 3 cases, my lord, apply, my lord, here, because, my lord, there was no issue of jurisdiction. In fact, other than Whirlpool, and Whirlpool recognizes that, my lord, jurisdiction and natural justice, breach of principles of natural justice are 2 important facts. My lord, on the basis of which jurisdiction will be exercised. But just to put everything up to date, I want to tell your lordship, my lord, the latest Supreme Court decision on this, which says if there is a question of law, the court will entertain it. Yes, my lord, kindly take, my lord, 2023. No, I'm showing it, my lord. This, my lord, kindly have a look at para 8. My lord, paragraph 4 was, my lord, deals with general maintainability. Kindly come, I have it here. Paragraph 8, my lord, kindly come to, my lord, that apart we may usefully refer to the decisions of this court in so and so. What appears on a plain reading of the former decision is that whether a certain item falls within an entry in a sales tax statute raises a pure question of law, and if investigation into facts is unnecessary, the High Court could entertain in its discretion, even though, and unless exercise of discretion is shown to be unreasonable or perverse, so and so. In the latter decision, this court found the issue raised by the appellant to be pristinely legal, requiring determination by the High Court without putting the appellant through the mill of statutory. What follows from the said decisions is that where the controversy is a purely legal one, that's, my lord, whether satisfaction is required or not, and it involved and does not involve disputed questions of fact, but only questions of law, then it should be decided by the High Court instead of dismissing on alternate. And, my lord, this is in line with a Constitution bench judgment referred to in Whirlpool. Referred to in Whirlpool, paragraph set out.
My submission would be without this is the purely technical ground.
It's a question of
The issues have already been considered in the by the Honorable Supreme Court in the case of Commission of Income Tax Madras and SV Angidi Chettiar. This is in 1962 44 ITR 739. That with regard to the satisfaction.
my lord,
That is all true.
my lord, Calcutta discount, my lord, which is referred to in Whirlpool.
Yes.
My lord says, my lord, if it's a jurisdictional issue, it is the duty of the High Court to decide it under Article 226. And that's a tax, and that is an income tax matter.
One can say everything is a judicial issue.
Ashun.
But Your Lordship, kindly consider what is the judicial issue. Or in taxing statute, my lord, everything cannot be a judicial issue.
Final hearing.
Challenging.
My lord, may I have your
Yes,
pictures,
yes.
please?
The only issue that calls for consideration in the series of writ petitions filed by the petitioner, though the above writ petitions have been filed, inter alia challenging the show cause notice dated 4th January 2025 No, call that matter where an order has been passed. Yes.
So that is 4.
Yes, yes. Yes. Auditor here. Yes, yeah, your officer is here. Ask him. Ask him what is his explanation. Why is he not providing you with adequate instructions? Yes. Yes. Yes.
And after Milord's order also. So it was see at the Sevotam Central receipt section, that is at the customs house. Milord,
No, no, did he receive it?
Milord, he has received the soft copy, and since
When did he receive the soft copy?
I had yesterday evening, means at the time original sentence after, sorry, not evening, then only I inquired.
I'm not doubting you, Miss Mukherjee. Your inquiry, I understand. When did he receive it?
Ask for copy, Milord.
Ask him when did he receive the soft copy?
He
Ask him when did he receive the soft copy?
today he said on my end.
It is not so simple, madam. Tell him, put him on notice. No, put him on notice that it is not so simple by telling today he got it. This court will inquire into the matter and find out when he received this. And if there is a departmental inquiry will be directed to be initiated against him. So unless he comes with the truth when he got it, it will be very difficult for him. Ask him when he got the copy. When?
12 p.m.
Today 12 p.m. he got the copy.
He asked, means obtain the copy from the e-portal because he is still not finding the copy.
So this was available on the portal? It was, no, tell him it was available on the portal. He downloaded from the portal today. Ask him to use the microphone.
सर आज 12 बजे के लगभग मेरे सीनियर ने मुझे ई ऑफिस में भेजा था और मैंने कल सर पेटिशनर के काउंसिल है उनसे फोन पे बात की थी कि आप हमको व्हाट्सएप पे इसका कॉपी भेज दीजिए जिससे हम हमारे एंड पे जो भी नेसेसरी एक्शन है वो ले सके.
So it was available on the portal?
Yes, in the e-portal.
I'll ask him to file an affidavit and explain the position. He can't just sit there, act against the department, sitting. He is being paid by the department. He cannot act contrary to the interest of the department.
From his phone, it has reached him.
Hey, madam, it reached him today, but it was available on the portal. Why aren't they working? Matter, this has been served 1 month back.
We went to some senior official. There are
So who is the official who is holding on to this and not disclosing it to him? I want his name. I'll pull him up as well. Who is the person concerned who is detaining files? Not permitting the information and the instruction to percolate to you for you to make submissions before this court. Because you are defending the department. If you are not appropriately instructed, madam, how can you defend the department? Does he understand the consequence? What is his designation?
Sir, I am inspector. In my lord, I
And the junior most person has been sent. Who is the law officer in this matter? Who is the law officer who is instructing? No, very well. Who is the law officer?
instructing me.
No, who is the law officer? He is the person he is in contact. You only get instructions to him, madam.
Not only there.
In serious matters, this is the gentleman who instructs you. What is his designation?
sir inspector. My lord, inspector.
Inspector. And he gets instructions from whom?
So there are different sections. It is as per the writ petition file and against which section, suppose it is import, then the receiving the writ.
He is doing a liaison, I understand.
Yes,
Nothing more than that. He has no instructions for him to give you.
yes, Lord, that is the fact. And it
Then
goes
who
to
is the officer concerned who is required to give instructions?
Sir, depending upon the writ, it goes to the concern section. Suppose there is on some duty element who has passed the order, it will go to concern section, and concern section, they will I will send an inquiry to them, request to them, and they will send an inquiry from that concern section. Concern section will send the parawise to them, and they will forward them. You know, they are doing the legal section. They are from legal section.
He is from legal section.
Yes, Milord asked me, Milord's order was.
No, naturally, who is instructing you?
Was instructed.
So far as you are concerned, madam, if this is the instruction you are giving from this gentleman, what will happen to matters? No wonder matters are not, you are not getting proper instructions.
Allegation, Milord, it is my submission, Milord, knowing that from the experience, depending upon the allegations that is put forward in the petition, they forward to that concerned section, Milord.
No,
Suppose
someone responsible should be here. Someone higher in rank should be instructing you.
one concerned like a court officer,
Correct.
CHO, like that we have in other departmental matters, Milord. But in this department, CBIC, Milord, there are different set of officers dealing with
The moment the court has no intention to ask him to come to court. But if this is the situation, he will land up in trouble.
But it is not,
Does he undertake that in future immediately he will be proactive? Does he undertake, ask him that in future he will be proactive and find out immediately when a writ petition is served and give you instructions?
And also pass this on to the department.
Yes,
other officers.
ask him.
Because in this case,
Or if you want, I will call for others.
And also you will follow that immediately return served, you will take up this.
You file an undertaking before this court that in future this will not happen. The concerned officer, that is Rajat Kumar Meena, Today
A
the
lot of pressure.
situation here is that so many matters are pending now. And we have to continue and
Yeah,
hear out at least the matters. So that's why I'm trying.
Well,
Madam, come back.
well,
And please don't take any steps. Maybe if no, if you take any steps, I will consider it as and when it
but
happens.
two
I'm
and
not saying. And no order is there, no oral direction is
but
there.
2 and 3, my lord, in which tar was there, I am not asking anything. Let them issue that only waiver certificate till the court opens. There no money is to be paid by them. As your lordship has
Miss
telling
Atta, having regard to the allegations,
not in this matter, my lord. 2 and 3.
no, 1 minute. Having regard to the allegations made in the petition, I direct the respondents to
No, that's the tar matter. Really, today is not the time left to argue. Really. I'm only saying. Yes. What I'm only saying this that
he is suffering every day.
30,000 rupees every day.
He has brought one goods
30
within the country without DGFT permission and without BIS license.
that-
Now,
that
to
I
that
explained.
effect, if we have to allow, then it will be dangerous.
No, no, don't allow.
We have not allowed him.
He,
So it
he's
is
suffering
subject to-
demurrage. He's
No.
suffering demurrage.
No, my lord, he has to suffer the consequences of not following the procedure
I don't-
established by
Alternate
law.
place you arrange.
My lord,
You ready and
no,
willing?
the goods are lying at the container freight station. My lord, these goods are lawful. I'm not opening the case. I'm only, and my lord has directed me, Sterling Agriculture, that they will be issuing only the Warface waiver under 6L of the handling of cargo in customs area regulation.
Cannot be at the
Let
matter
them
of
issue,
goods.
that's all. We will argue for
matter of-
release after your lord's
The waiver you allow
But
because you are holding back.
My lord, holding
That
back
is subject to final order.
My lord, holding back is subject to an investigation. Summons
Now,
have been
now I have
issued.
to argue
He
the case in
He
that
took
case.
time for that, and he will be coming tomorrow.
Then
Place your case, please.
I'm to argue this case.
What interim order you are seeking today?
Yes, my lord. But these goods are freely importable, and my lord, I will only show a page 65, my lord.
No, without giving you an opportunity, I cannot decide this.
No. But that what I'm only saying
My lord,
just for a
after
moment.
vacation,
My
your
lord,
lordship keeps it up after vacation.
Wait, after vacation also, all the matters cannot be taken up. So I have to take a decision. And
Yes,
at the moment, my lord, I will only say this that I am asking for release of the goods because goods are freely importable. These goods bear the mark of the tire. And page 66 is the photograph I have annexed.
yes.
Page 66. Right now, there is no time left for us, my lord. We have to cooperate with the court also. I'm only saying it is not his loss. It is, and I am suffering 30,000 per day.
Per day.
Per day, 30,000 rupees. And 61L certificate they will issue. It is in their hand. They can write on the stationery and give it. Bus.
What is 61N certificate?
my lord,
61L is, my lord, is
we have instructions. from
handling
the
of cargo
department.
in customs.
Lordship will kindly see our clear instruction is that as
এ দাও তো ওই কাস্টমস এর ম্যানুয়ালটা দাও তো আছে আমার কাছে স্টিকার দেওয়া 61L আছে আনালাম তো আগের দিন চেম্বার থেকে আনো Yes, you want a 61L certificate?
Yes. So after that, we will argue the case.
What is a 61L certificate? Show me, Mr. Banerjee. 61L certificate is exemption from the demurrage, nothing more.
That's all.
You are holding now. You are retaining the goods. This is
my lord,
under.
it is a subject matter of investigation.
Correct.
If the person wrongfully brings something,
You are not discharging the goods. You are only exempting him
Now-
from.
now-
Listen,
Yes.
what are you doing? You are exempting him from the demurrage. Nothing more
That's-
than that.
Yes.
You are not releasing till the investigation is over. You say that you are holding investigation. Perhaps the language is such. I'll find out. I have read.
Lordship will kindly see because it is a measure when there is prolonged investigation.
Now there is a prolonged investigation.
It is 6 months only. 6 to 7 months is only going on.
Say every day 30,000 rupees demurrage is there.
Yes, my lord, it
One-
has
one
been
crore
passed.
ওই তো ওখানে আছে এই তো পড়ে আছে
1 crore is the damage
দাও
against this.
দাও ফাইন্ড আউট ওখানে দাও
It has been parked in the CFS.
আরে you decided, nobody is stopping you.
But why we
Law
give an
permits
exception?
you.
But-
Law permits you to consider. I'll direct you to consider
Yes,
this.
consider.
You have considered.
No, my lord, we will consider.
And that's what I'm saying.
But I'm saying that you.
Arey, you consider it.
Yes,
You will
my
not
lord.
consider it also.
No, consideration. Why will I stop?
2.151.
Yes, Arey. Or if he wants to remove it to a different warehouse, permit him.
151. That is this at that page. 2.151.
2.151.
He can apply for the alternative removal of site for warehousing.
So I'll permit him.
Yes, let him make a representation and they will take a decision within 7 days.
Challenging the yes. Next.
Wait for an indulgence, Proceed. Proceed.
Wait, mentioning is there. They will mention, yes.
I want to mention.
Wait. Wait, madam, wait. এই কটা মামলা আছে আর্জেন্টিতে কটা আছে বুঝলো? এইটা অরিজিনাল সাইডে রেখে দিয়ে দাও তো, ওই জাজমেন্টে ঢুকিয়ে দেবে, বেরিয়ে গেছে। না এটা ছিল না, এটা ছিল। ঠিক আছে, বলো বলো বলো।
Kindly.
Lordship, may I mention item number 128 of the combined monthly list, Lordship? Lordship, Lordship, all of a sudden yesterday the petitioner received a notice from the respondent authorities asking the petitioner to pay the dues within a period of 10 days, Lordship, or to produce the stay order, knowing fully well the matter has been served over them that the court is going in the summer vacation. Lordship, let the matter be taken up tomorrow, Lordship. Leave to move. Lordship, Lordship may take up the matter tomorrow, Lordship. Okay, Lordship,
My
leave
lord,
to take
leave
move
to
vacation. Lordship. Let's see.
My lord, leave to move it before the vacation bench, my lord. Pursuant to the leave granted by lordship, my lord, the matter has been filed yesterday, my lord. The leave. Yes. My lord, paying the number. Yeah, tomorrow, my lord, I will not be available. My lord, oh, my lord, my lord,
Lordships, yesterday, serial number 15, your Lordships indicated not today and indicated me that I should try my luck today. But from daily list, it has gone now. But it is gone from the list, Lordships. It was made not today only. Serial number 15. No, not been called on Lordship, but kindly instructs.
my lord, may I
Lordships.
permitted to mention, I'm praying for order correction.
No, I'm not saying for calling up, but it has gone from the list. Where it.
May I permitted to mention, I'm praying for order correction is yesterday uploaded. 2 order. Months. There is error in months. I'm great.
Daily list item number 1.
Lordship, in this matter, this is a central excise matter, your Lordship. In this matter, I have impugned before your Lordship the order passed by the Commissioner Appeals of Central Excise, dismissing my appeal on the ground that I have filed the appeal beyond the condonable period of delay. Lordship, urgency is that department is issuing me recovery notices constantly, your Lordship.
My lord,
Lordship, then kindly after vacation, your Lordship.
my lord, one request, if they can give us a copy, because and a copy of the and Mr. Banja.
Lordship, after vacation, Thursday, your Lordship. Lordship, monthly is kindly not here. Your Lordship, they are issuing constantly recovery notices, your Lordship. Till March, they have issued.
Grateful, my lord.
Item number 2.
They've issued a recovery notice without the order, without the adjudication order.
Now, after a long time, they are now restricted. Order has been passed, sent by speed post. I shall have to bring the records.
I'll dispose of that.
My lord, in fact, no, my lord. They wrote a letter also.
Well, today I do not have. No, I do not have the document of sending the document and the order in original. We have got the instruction, but they have not sent us
But
the.
actually, I'll tell you, Lordship. Show cause notice not served. Hearing notice not served. This is the case. This is the instruction.
They have annexed it. Personal hearing they have annexed.
That's
What
the
have-
notice of personal hearing, the show cause notice, and they've written in the letter. They've written in the letter that they have not received it.
Well, they have appeared also.
Show me the order.
Well, I cannot. Today I cannot.
Where have they appeared?
No coercive action. No coercive action. of extending the time.
No, it
by
is not.
keeping it in
They've
their
written a
docket.
letter.
Yes,
They've written a letter asking for it.
shall bring the entire records.
Please,
Lordship.
deeply obliged.
Item number 4.
Oh.
There is a 168 matter, my lord. Reason 168A, my lord. So, my lord, by mistake, my lord, I am seeking for.
I'm for 4, my lord. My lord, here the matter is, my lord, the petitioner is a miller of paddy, my lord, into flour, my lord. 100% of the milling is to the government of West Bengal, my lord, Food and Civil Supply Department, my lord. My lord, the price of milling, my lord, milling is into 2 different steps, my lord, whereof it is crushed, the wheat which is sent is crushed. Thereafter it is packed, certain fortification is added into, my lord, and thereafter it is transported. But for each activity, certain amount is mentioned, my lord, and time to time a notification is issued by the state government against that, my lord. My lord, according to me, I qualify not to be taxed under notification number 12, serial number 3A, my lord. My lord, if lordship, I can place before your lordship, my lord. My lord, thereafter, my lord. My lord, on that day, my lord, herein after, my lord, what has happened that I went for an advance ruling, my lord, under section 96 of the Act, my lord. 103 of the Act says, and the advance ruling, against the advance ruling, there were 3 questions put in before them, my lord. My lord, after the show cause notice, I have challenged the show cause notice, my lord. I have brought to their notice that I have challenged the show cause notice, which is pending before the court, my lord. In spite of that, a demand has been raised, demand of near about 5 crore rupees has been raised, my lord. And it has been raised in the month of January, my lord. And my appeal, my writ was filed before your lordship, my lord, in the month of March, my lord. And there's an anticipation, my lord, that the recovery during this pendency, my lord, during the vacation will be initiated, my lord. And my lord, they do not have the, my lord, they do. My lord, March, my lord, within 2 months, my lord. My lord, within 2 months, I filed this writ. My lord. My lord, there is.
Wait, I'll place it on the reopening date.
My lord, very well, my lord. Very well.
I'll go to the vacation. Better you have a better option, sir. I'm granting
My lord,
you leave.
similar matter has been tested before your lordship, my lord.
First দিয়ে দিও ওটাকে এটা আপডেট করে এটাকে নিয়ে নেব রিওপেনিং ডেটে হ্যাঁ
Well, similar matter, lordship has stayed, my lord. Similar
I
matter.
have to apply my mind.
Well, definitely,
Consider your matter. It's not so
No, no.
simple, Mr. Churadia, that I will just allow the matter or I'll dismiss it. Either I dismiss or I allow, whichever way it happens.
Well,
You
yesterday,
never know.
before yesterday, not finding it in the list, I was very depressed.
No, I had directed
Yesterday,
the matter to go.
I was very happy that it will be at least heard.
No, I'll be heard. I'll be taking up. Next, Dakota Washroom.
अरे सौ पच्चीस
Only extreme urgent matters I'll take up. Otherwise, I'll not take up any other matters from the appellate side.
But tomorrow,
Because today is tomorrow you want to come back.
No.
Today only extreme urgent matters I'll take up. Otherwise, I'll not take up. Yes.
I'm for the respondent.
Please,
Yes.
my learned seniors are online.
Yes.
My lords, and what has just fallen from my lords, I have to be honest, it is not a life and death matter. The financial year has gone by, so I will leave it to my lords. My lords can have it after the vacation.
I tell you why today was an original side date.
Very well, my lords.
But because of the vacation, only extremely urgent because there are other days, another determination. So I have to take up that matter also.
No, my lords, I will not press. I will not press. I know it is not an urgent matter. We can take it up after vacations.
Yes. Next.
Great.
উপর দিকে দিও এগুলো সব আর্জেন্ট ছিল তো লিখে রেখো আর্জেন্ট আমার কাগজে লেখা থাকে আর্জেন্ট ছিল তো এই জন্য সেইভাবেই আসবে একটু তো তলায় আসবে ঠিক আছে
Item 6.
Millards, in this petition, Millards, we have challenged order under section 83 of the GST Act, Millards. The urgency is this, Millards.
these orders are of January and March of 2025 this year, my lords. We have challenged it in the second week of March, my lords. Subsequently, on the 16th of May 2025, my lords.
Yes, where is that? Yes, yes. Continue, sir.
Yes, my lords. On the 16th of May 2025, my lords, the state tax officer who had passed the order for provisional attachment has issued me another form of a letter, my lords, asking me to provide certain documents and additionally provide bank guarantee.
Did you challenge the order?
My lords, I have challenged the provisional order,
Yes.
provisional attachment order, on the ground that, my lords,
Where is that challenge?
my lords, in this writ
For
petition.
revocation of that under the provisions?
159.3 he has not in.
Rule.
Yes.
159.3.
Yes, have you?
No, my lords. My lords, there is this judgment of your lordship only, my lords. It's in Lakshman Saraf. I understand, my lords.
159.3 without I will not entertain you.
Yes, my lords.
Where is the five?
My lords, may I just point out one thing? I understand.
Without going there, I will not entertain the matter.
My lords, I understand, my lords. I understand that rule, which just kindly allow me to distinguish as to why I will not fall under rule 159.
Cannot.
My lords, because section 83.
Distinguish, then you come after the vacation. I'll not take it up now. Oh, you want to distinguish, come after, but I'll be very clear.
I understand.
I bound my own judgment and appeal was preferred from that order, Mr. Chakraborty. Yes, an appeal was preferred from that order, but
no order has come. Lakshman Saraf judgment of your lordships, no order has come by the division bench yet, my lords.
No order is there.
No.
Appeal has been preferred.
Appeal has been preferred. Single bench's order is still ruling. No stay also has been granted.
There are two other state houses also followed this 159.5.
It's been difficult for you, sir.
I understand, my lords. I
Now,
understand. Much obliged. My lords, all the matters are identical. 5, 6, 7, 8, 9, 10.
Yes, all goes after the vacation. If you have not challenged that, I will not take it up.
My lords,
Challenge it, come, I will take it up. Today, they have issued, you see, it's a draconian provision.
I understand.
Correct. But still then the provision is there in the statute book and the statute recognizes the right of the authority to issue that.
Yes, my lords.
So therefore, you have to go within the parameters of the statute and seek for revocation of that.
My lords, my only submission is that the law grants commissioner this power. And I am answerable to the commissioner.
Order.
Yes, my lords, over there, commissioner had passed.
That I will
No,
change the
absolutely not.
today without
Absolutely
this.
not.
And
No,
the
no.
appeal is pending. You were there in the matter, no? Appeal is pending. Go. What happens in the
Milad,
appeal? Let us see thereafter.
Can I just raise one point? Well, one point. I will not take much time, my lords. The point of distinction, which I will elaborate later on, my lords, is that Section 83 allows commissioner to pass an order. Rule 159 allows me to file an application before the commissioner for removal of that order. Provision. In my case, my lords, is the assistant commissioner who's passed the provisional attachment order.
Jurisdictional issue.
It's a jurisdictional issue.
This issue has already been covered by judgment of Radhakrishna. It can under 5.3 it can be delegated. Kindly see it already
Not
been.
done
My lord,
today.
this matter.
Mr. Chakraborty, not today. After the vacation, come back.
Asking only, but this matter, there are many facts. I have asked the officers to be present. No, kindly.
I'm not taking up today.
No, today, kindly don't take this matter. Whenever kindly fixes a date, because there are a lot of my lord corruption.
You mention after
Any
this.
day,
You
my
are
lord,
holding
because
on to the order. I have not interfered.
No, I want the officers.
Yes,
to be
call the
present
next
because
matter.
of
Call the next matter. Call the next
Yeah,
matter.
same, my lord. 6 to kot no?
6 to 10, my lords. 6, 7, 8, 9.
11.
No, these will come in the monthlies of June.
Yes, all June.
All June.
Enough.
11 is
no further matters on this side.
Lordship, 11 is I was ordered. I got a contract from PWD in the before 18 July 22 when the GST rate on government contract was 12%. That contract ended in the post GST regime.
Urgency,
Lordship. DRI, State DRI department has issued me a notice and they are asking me to pay up 99 lakh rupees when I've already made 4 representations to all the PWD department, which they are sitting tight. So Lordships may direct the Lordships similar matters. The coordinate bench, in case of these matters, have already.
Yes. And in fact, in one of the matters, Justice, Chief Justice,
Has filled my lord's order. Division.
There is yes. I remember there was an appeal. So give me that order on that date.
I'm upheld in the appeal court.
Upheld by appeal. Take a printout of that order and tag it with that file. So it will be easier.
Yes.
Acha.
Lordship, my only predicament is my representation is pending. In the meantime, DRI is asking me to pay 99 lakhs on the same value for the same 6% differential.
No, here, I don't know whose matter. In one of these matters, such an issue was there, matter went up to the division bench. The Chief Justice, our Honorable Chief Justice had directed the authorities to make everyone a party and then proceed. With the,
So that was KMC matter.
yes, yes.
Kolkata Municipal Corporation. These matters before Honorable Justice Nizamuddin.
It's your matter.
No,
That
that was different. So, Lordship, these matters are representation matters because the government itself has stated you will get.
I'll direct the authority to reconsider.
Lordship, consider, but Lordship, my DRI, they should not proceed in the meantime. My urgency is that
till the decision is taken.
Yes, Lordship, that is the.
Now, let me understand. What are you showing? No, which page?
Oh, Lordships. DRI notice, Lordships, or my representation?
Where is that? Which
My
page?
my representation.
Yes, which page?
Representation for 81.
And next
representation is Lordships at page 89, and after that page 116.
Saudi and company.
There are 4 work orders, Lordship, involved. So there are 4 PWDs, various divisions are there.
But only thing, my lord, whether this demand is.
And last one. I'll hear you. Without going through, I'll not pass any order. Last one.
Lordship.
Last one.
116.
160.
116, Lordships.
আগে 6 থেকে 10 অর্ডারটা টাইপ করলো না অর্ডারটা আর কিছু করো না
And then Lordships, one more is at 128.
Not necessarily.
4 different work orders, that is why Lordship.
Now the present, yes, Mr. Chakraborty.
Only thing, my lord, whether the demand is in restricted to those demand, those notices for PWD works or whatever. Now that is the only question. My lord, my land let us stay. We do not know, my lord, we do not know.
I'll provide it. Where is the demand?
Lordships, kindly takes the first notice at page 87.
Last demand.
Last notice is at page 107.
87 and 107.
107, Lordship. 107. After that, I have replied also. Lordship, page 109. After the table.
This is notice for notice of ascertainment of tax.
Lordships.
Ascertainment. So show cause.
No, not show cause. In fact, DRI, Lordship, state DRI, they are an investigation wing. After that, what they do, they directly go for recovery. Because they have issued this, we have replied. Now there is a liability hanging in my portal.
The present requisition has
They have
been
not
filed.
issued. That is what. Therefore, I am saying.
Tentative direction
Page 112.
upon the Group 4 matter, group 5 matters. 12 is group 4 or group 5 matter?
Group 4. 12 group 4.
Yes, urgency is there, Mr.
Urgency. Only status quo still reopening your
So what are you challenging?
They are challenging the adjudication order, appealable.
Maybe appealable. Also, I can satisfy that this comes within the parameters.
Show me.
That's your losses. Can you have a look at it? My basic contention, the adjudicating order is the what the nowadays we use the language computer printout of the so-called notice. Copy paste rather, I forgot the copy paste. Now your losses straightway come to continuation of page 286.
When was it passed? Urgency. 16 May you have filed it and you have come. When was it passed? Order passed when?
No, that's some days before might be. I give you a loss. I just page 239, 20th February. Date of issue 3rd March 2025. 3rd March 2025.
There cannot be any urgency after the vacation. Come after.
Kindly let them not to take any.
Nothing will happen. Usually in these matters, nothing happens. Usually in these matters, nothing happens.
Till reopening.
It is better you come after the vacation. It is better.
No, I will be. I'm not saying that your losses stay all that. Status quo as of today till 1 week.
No, they have to entertain the petition. Especially having regard to the fact that you have a efficacious alternative multi-tiered adjudication process in the form of appeal under section 107 and under 112 of the State Act.
No, 128 under the Act. 120.
Yes,
that's your loss. If I can show your loss.
I will hear you because this matter would require consideration. You may have a good point. Take your chance after the vacation. It will be better also.
But I'm not saying your losses pass an order.
But also you can do the vacation if you want. I can grant you.
No. I can do if your losses is one.
Yes. After the vacation, it's better.
Well, then the losses.
It will appear.
Item number 13.
Only appellate side today was not fixed.
No, I know.
Today I'll be taking up extreme urgent matters. I'll be taking up. Otherwise, then that all after original side was the date fixed for today. Yes.
This is my lord. This matter is fall in this category. Why? Because
you have directed. You have for you, Mr. Nayak had to come here.
Yeah.
On a day which is not fixed for hearing of group 5 matters.
I'm grateful to my senior friend.
Yes.
Honorable court.
Yes. My lord, this matter relating to my lord.
Societies, this matter has been filed in the name of the cooperative society to a person claiming to be the secretary of the society. And he is challenging a memo in which the election of the board of directors was cancelled. And new BOD was directed to new election.
My petition, my learned. Yes, I place my point.
He's saying, Demar, let me get.
If your lordship sees, petitioner's name is the cooperative society and is represented by a person, Gangadhar De, who is calling himself to be the secretary of the society. Where in this writ petition is a memo issued by the RO, the returning officer, wherein the earlier BOD which was held was cancelled and the ARO, one more ARO has been added in the election process and both of them have been directed to reschedule the election of the BOD. So as on date, there is no secretary, no chairman. If this memo subsists, so in this case, your lordship, they could have very well come with a personal capacity, but as a society, they cannot.
I'll not accept this petition as a society. I'll accept it as a as an ordinary member.
Ordinary member, your lordship. It can be, your lordship, but not as on behalf of the society.
Election matters. I'll accept it as an ordinary member. I take it.
Then in that case, your lordship.
I satisfy this court. I satisfy that court.
Has to be.
Let me find out from it.
Yes. I will place my case.
Yes.
Kindly take page number 14. This is the first notice regarding delegate election by the ARO. Got it, my lord? Kindly take the signature. Very interesting. And very interesting matter.
13 January.
Yes, my lord. Thereafter, my lord, paper publication, page number 15 for delegate election. The last line. Got it, my lord? The last line. The
Nirvajan Falafal is over. 14 February. Then?
Yes. Thereafter, my lord, delegate my lord, elected, page number 16.
Two-tier election, delegates will elect the board now.
Yes, my lord, kindly turn page number 18.
Three-tier.
Yes,
Oh,
3-tier. My lord,
delegates
yes,
will elect the
delegate, we have board of directors and office bearer.
Delegate election is the main vital election.
Thereafter, board of directors, thereafter, office
office
bearer.
bearers will come later.
Yes, yes.
This will
Let's
start at next.
next. Now I will satisfy, my lord. Kindly turn, my lord, page number 18. That is the notification issued by the ARO for board of director election.
Yes.
Very next page, page number 19, that is paper publication. That is very important. I want to read it, my lord. And it is by the ARO. Atodara, got it, my lord? The last line, middle portion. Porichalok Mondolir Nirbachoner notice. Got it, my lord?
Yes.
পহলামপুর সমবায় কৃষি উন্নয়ন সমিতি লিমিটেড পহলামপুর সিঙ্গুর হুগলি এতদ দ্বারা পহলামপুর সমবায় কৃষি উন্নয়ন সমিতি লিমিটেডের সকল নির্বাচিত প্রতিনিধি আন্ডারলাইন ডেলিগেট সদস্যকে জানানো যাইতেছে যে আগামী 12 মার্চ 2025 তারিখ বুধবার সমিতির পরিচালক মণ্ডলীর সদস্য নির্বাচন অনুষ্ঠিত হইবে সকল সদস্য নির্বাচিত প্রতিনিধিদের উক্ত নির্বাচনে অংশগ্রহণ করিবার জন্য অনুরোধ জানানো হইতেছে বিশদ বিবরণের জন্য সমিতির নোটিশ বোর্ড প্রধান কার্যালয়
Very well. Then after what happens?
Yes, my lord. So, my lord, this is paper publication. Thereafter, very next page, page number 20. Page number 16 was the delegate, and page number 20 is for the purpose of আগামী 12 মার্চ 2025 বুধবার তারিখের সমিতির board member নির্বাচনী নির্ঘণ্ট. And every member hand received by the delegates. Got it, my lord? There are, my lord, 42 members, they received by hand.
Sir,
And
what is
other
your
member
challenge?
is also
Challenge. I got
yes,
it.
yes, yes. I just placed it, my lord, in my way. Just give me 5 minutes, my lord, because that is very important. Because that is the allegation.
You come back. I'll first show me what is
Yes.
the challenge and then
Which
come
is
back.
challenge, my lord, page number 47.
Yes.
Well, after election, kindly turn page number 26 first. Thereafter, my lord, I will go there. Page number 26. Thereafter, my lord, the board of directors is elected and under section 32(5)(b), in the format, the ARO give the certificate. Kindly turn page number 26 is one of the certificate. That is board of the directors certificate given by the ARO. That means board of the BOD constituted under section 32. Thereafter, my lord,
Certificates are here.
yes,
How many board of directors?
12.
12 have been issued.
Yes, yes, yes.
All
Kindly
12
turn page
certificates
number
are
20. Yes, yes. Kindly turn page number 25.
No, I've seen that. All are there. Very
They all are there. And everyone got the certificate under the seal of the
After
year.
what happened?
Thereafter, my lord, all of the sudden, kindly turn page number 47, which is under challenge. The same ARO, under which provision of law he got this power, I want to know, my lord. Kindly, I put this question to myself. Kindly see, my lord, this one. Page number 47, which is under challenge. Whereas the secretary CEC, yes,
Yes, sir.
may I read, my lord?
Yes.
I just,
In some in substance, case,
No, it's all right. I'll hear all your open challenges very well. After having issued the certificate, where is the power to issue?
Because notice was not served to each delegate.
Where have you cancelled it? Where is your cancellation?
I never given to you.
Where is your cancellation?
That we have that.
Where is your resolution of cancellation?
Yes. Resolution, no. Election Commission is taking a decision. All have
You
not
have
been.
to take a decision. Where is
Yes,
that
yes,
decision?
Yes, yes.
Where is the decision?
Also.
After constitution of the board of directors, what is?
Because all have not
Wait,
intimated.
sir. Kindly wait. Then you go and arguing for the rest of the day. I will come back tomorrow.
Vote. Lordship. This is decision. Because all were not intimated. Now everybody everybody has been intimated. Board will be constituted. Program has been announced. What's the problem? 46.
No, sir. It is not so easy, sir. It is not so easy, sir. Once a board of directors have been constituted in accordance with the regulation, then
Not with accordance to regulation. Regulation says, my lord, kindly allow me, my lord, 1 minute, then, my lord, certainly all these to be considered.
where is the order
Law
of
states,
cancellation? Where is the order of cancellation of the election? Where is the order cancelling the election? This is rescheduling.
and my lord, that has been, my lord, annexed for FCR. No, election commission. Yes, yes, yes.
Without the cancellation, step by step. Unless you cancel,
This is an intimation to the RO.
sorry, I got it.
RO.
Without, where is the fill in the blanks, Mr. Nayak, fill in the blank. I want you, I will take it on record. Show me that cancellation.
That reason order passed by the election commission.
No, not that.
Unless
That
you are
I
in a
am-
position
at
to.
least to that extent, I don't have any instruction. Lordship, my point, my instruction is this.
Then come on the reopening date.
Lordship, kindly one. No, it is, if it is state. Lordship, kindly.
No, there's an address that you can't show me.
I
It's a
tell you.
vital matter if you
I
are
tell
not
you,
in a
Lordship,
position
no
to show.
order is required. Lordship, kindly appreciate. Let me complete it.
Yes, yes.
My lord, 46 delegate election. My lord, 46 numbers of delegates have been elected.
Yes.
So to that extent, there is no dispute. And delegate election is the main vital election. Thereafter, what will happen? The board of directors election.
How many board of directors are elected?
12.
Required to be elected.
My lord, 12 will be elected.
How many certificates did you issue?
Out of certificates have been 12. But all were not.
But how do you have the power to set aside?
We
the
will not-
election commission can, in
Lordship.
terms of the regulation, can set aside.
Lordship can set aside.
Can set aside.
If the
Nobody is saying that you cannot set aside.
Because
where is the order setting it aside?
you know that order, my lord.
Without that order, I am not going.
Tomorrow, Lordship.
No.
Tomorrow, Lordship, morning, first matter.
No,
I'm taking instruction. Below urgent matter, overnight we have been received. We have not been provided with
I'll place it after the vacation. I'll hear you.
Lordship, no stay in that event, Lordship.
Naturally, today's there is no order of cancellation.
Tomorrow, Lordship,
Where is that? Today's matter was there, served on you. You ought to have brought the order of cancellation.
It was mentioned overnight, Lordship, matter will be taken up. But I tried my best to give all information. Now, information.
Days.
Today.
When have you even served with the copy of the where is the affidavit of service?
Yesterday also can you see?
Where is the affidavit of service? Forget the mentioning.
48 hours not over. Election commission is here. Election to be conducted in Singur. RO is there, Lordship.
Session is Tuesday.
So tomorrow, first item. Nothing will happen. I will take me 2 minutes.
Nothing will happen.
2 minutes.
18. Today we are on 22nd.
22nd.
19th we have received it. 19th itself we have received.
My lord, kindly appreciate 2 days holiday, Saturday, Sunday. Then kindly appreciate when I'm just.
Where is holiday, sir? Sir, which is the holiday, Mr. Nayak?
Lord,
which is the holiday?
My lord,
19th was a holiday. No.
Saturday.
Thursday, enough time is.
I'm going. Lordship, 1 second, Lordship. 1 second, Lordship. Can you allow me?
I will not decide the matter. I will place it. The moment you can show it was cancelled, I will restore it.
No, whether order was passed, my lord.
You will have to reschedule it.
My lord, interested to know whether any order has been passed to the
Correct.
next
That is only A. And second, what is the power to cancel?
That I am satisfying here and now. That power is there.
But without the order, that will not.
I am telling you, your lordship, that inquiry. No. Let me base the case. Thereafter, my lord will decide.
Tomorrow I will not take.
First point is this, my lord. Upon receiving the complaint of my lord 12 DL delegates, they have not been integrated. That is with me. They have said that we have not.
You know me. I only place matters for consideration on the
That is
penalty
true,
phase.
Lordship, but
Last date I will not place any matter.
Fact
for
is otherwise,
consideration.
Lordship.
And that is the reason why today is not a group 4 day, a group 5 day.
I know, my lord.
But still then the matter has come
But
up
on
because
misleading-
all the matters
on my lord, misleading statement, something has been going to happen. That's why not opposite.
Regulation.
1 second, Lordship. My lord, this is
May I hand it over?
my lord, this is
not this.
my lord, this is the representation of the my lord 12 my lord delegates. Kindly have a look to this, my lord, first thereafter. Kindly,
I'll buy an affidavit. I will not take it up. Today you have to show me your order of cancellation that I can see. Not what delegates have given you. Order of cancellation has
my
to
lord,
be.
under the law, Lordship, kindly appreciate law says for cancellation, no
Where is-
order,
where is the
no
provision?
order perhaps is not needed.
Achha,
I
wait,
tell
I'll
you,
record
Lordship. I
that.
tell you, Lordship.
I'll record that.
I tell you, Lordship. Now, my lord, complaint has come that all the members have not been intimated. Delegates, those who will form the board. We have made, my lord.
Come to the regulation, Mr.
My lord,
Nayak.
inquiry has been conducted.
Mr. Nayak, come
It
to
is
the-
found that all has not been, my lord,
I
served.
mean, I will record your submission on this. Come to this. Mr.
Tomorrow
Nayak.
at 10:30. I will take only 2 minutes time, Lordship. Because I don't like to, my lord, convince your Lordship in different manner, showing revision. I want to, my lord, come to the point that whether any order is there or not.
Provision which permits you to cancel it, suo motu.
I will take a decision, my lord, Election Commission 35(1).
Suo motu. Suo motu.
No, not
Without hearing the board of directors whose elections are sought to be cancelled, Mr. Nayak.
RO's report, Lordship.
What to him?
My lord, under section, after formation of board of directors under section 32, they ought to adopt the section 34 proceedings. That is dissolution and reconstitution of the board. They never adopt the section 34 proceedings. And not only that, my lord.
Yes.
Page 44, kindly see.
And each and every one got this notice. I will place it here and now. Kindly turn page number 44 and page number 20.
Six members notice.
Today delegated. Correct? Nobody is disturbing it. Now there is, according to you, there is no board of directors.
Your Lordship, as because we are.
Correct? There is no board of directors. Please understand.
Yes.
There is no board of directors.
Yes.
They are third parties.
They are third parties.
Correct? Not third parties. They are members, ordinary members.
No, delegates. They are delegates, Lordship.
Members, delegates.
They are all delegates.
Yes.
Today you want to induct other persons as board of directors by an election.
No.
Correct, by a fresh election.
They
Correct.
also-
So I will examine that.
They will also.
I will examine that. This is not stalling of an election process. Why are you in such a hurry to proceed and conclude it?
No, very well, Lordship.
You
That
come
will be
after
done.
the vacation.
Lordship, kindly come
What is
to
your hurry?
page 49, Lordship. Kindly.
Yes, yes.
No,
I will
all-
also, because what Mr. Sureka has submitted, they had not gone there. I will examine that aspect also. They have, because they have, according to you, they say that they are not required to go there. But you had inquired into the matter, and on the basis of an inquiry, passed an order. I want to see that order. I will direct the election commissioner to file an affidavit in this matter on the reopening date. Until such time, no further board of directors will be
would be kind
constituted.
enough to
There is
consider.
no difficulty in the because this is a very non-normal process.
Your Lordship, our point is that.
He is not there. I am not protecting him.
Your Lordship.
Understand?
Your Lordship,
I am How are you concerned? How are you concerned if I say that the new election will be stalled till the next reopening date? Till you produce.
We are not.
Then you are saying so.
We are not.
I am not.
Lordship, no. I am not on that. Only I'm just pointing out, Lordship.
The first day, he cannot get all the orders.
I am not saying
Today,
that
if I allow his
we are
petition,
suffering any prejudice. My Lord's intention, I appreciate. My Lord, I bow down.
I want to see a test out.
No. Only one thing is to be clear. My Lord, 42 delegates. Now, my Lord, 30.
I have understood
No,
what you are saying.
36.
You are saying that the election has been set aside, correct?
No, not also that.
No.
Actually, election has been
Please, not that.
board of directors election has been set
Not
aside.
that. It has
No,
not been
that.
given effect to. Not set aside. Look, I am telling you. Now, Lordship, 42 total delegates.
Then how can you reissue?
Lordship, kindly, my Lord, just
Yes.
try to allow me to complete
Yes,
it, Lordship.
yes.
Mr. Sureka might have, my Lord, in his own way he has said,
No.
but I am telling it, Lordship. 42 delegates. Now, my Lord, very close manner, it was direction was given to the office staffs to issue notice to everybody. They have managed, my Lord, the office staff. Only, my Lord, for 36 have been, my Lord, intimated. Others have not been done.
I'll
Lordship,
test it out. I will test it out on the reopening date.
1 minute, Lordship will consider. Kindly 1 minute, Lordship. 6 persons have not been intimated. Now, my Lord, they have made a representation before the RO that we have not been intimated according to law, my Lord, section rule 45 says that I should be intimated. I have not been done. Inquiry has been, my Lord, conducted. In that inquiry, my Lord, inquiry officers have been appointed. They were called on to justify their plea that yes, they have been intimated. They have been informed. One second. They did not turn up. When the election RO,
If you want to argue the matter, you argue. I will say. Otherwise, take your
second,
seat.
please, fact. RO come to the
Take your seat.
RO come to the conclusion.
Today you cannot get everything. What do you
Lord,
want?
RO came to the conclusion they have not been intimated. Therefore, it will be better for the
So there
interest
has
of
to be an order. It's a judicial judicial proceedings. Where is that order?
Lord, assuming Lordship, there is no order.
No, there is no order. Then the further election process has to be stayed.
No, my Lord.
Further election.
My Lord, kindly come to 47. Once kindly come to 47. 47, Lordship.
Yes.
47, Lordship. Kindly come to that. 47, Lordship. That is, my Lord, after all these complaints, my Lord. And whereas, last paragraph, Lordship. Whereas to conduct free and fair BOD election of the Pahalampur Milord Society, Juma Mukherjee, CDO and Hooghly range is hereby appointed afresh as ARO, Pahalampur village, along with Shiner Sets Hooghly range to conduct and supervise election to the above noted society in accordance with the regulations as laid down in West Bengal.
This is the order, Your Lordship.
And this is the order, Lordship. Can you see?
This is the order.
Which order?
The order
Of the hearing conduct.
It's an order which Your Lordship was seeking.
Yes, where set aside.
Kindly see that.
I'll see that. Yes. So this is the so cause.
Give me a copy. Give him a copy.
Give me a copy.
Copy আছে দাও তো।
একটা কপি আপনার কাছে হবে, দেখুন ইনস্ট্রাকশনসে আছে, ইনস্ট্রাকশনস
আপনি পেয়েছেন এটা দেখুন না।
না না
না,
কপি
না,
পাইনি
কাছে
তো।
নেই,
কপিটা ছিল।
আপনার কাছে ইনস্ট্রাকশন
এই তো আসছে সব এসছে। দিস ওয়ান নট দিস ওয়ান। একটা এক্সট্রা কপি আছে কি? এটা দিস ওয়ান তো?
No, not this
এটা
one.
3/4
No, this not this one. There is a
and order also.
proceedings.
অর্ডার তোমার প্রশ্ন বার করতে পারিনি, খুললো না বলেছি না, দেখো লিখেছি, দেখো দেখো লিখেছি আমি, ওটা খুলিনি কালকে, ডাউনলোড করা গেল না এক্ষুনি। 1 সেকেন্ড প্লিজ।
Behind the back একটা অর্ডার নিয়ে নিন।
অর্ডার নিয়ে নেবে?
নো,
এখানে মানে বলে
এভরিথিং হ্যাজ বিন ডান প্লিজ।
No, wait. This is all submission. Where is the order holding that is cancelled?
The second last of the last paragraph, kindly see.
Yeah, I've seen that. I'll place it. The returning officer Hooghly opined that it revealed that there is a gross negligence in serving of the BOD notice schedule on all delegates who were not aware of the nomination schedule. So neither they could submit their nomination as candidate nor propose second suitable candidates in their favor, which violates the democracy of the election process. Moreover, it could be concluded that Himadri Kormokar and Kuntal Shatra, staff of the society, did not follow the instructions of the heir of property and did not publish the whole schedule in the newspaper, and also all delegates were not served with the BOD election schedule by the local delivery under proper receipt. So he directed to issue show cause letter to Somen Mitro ARO. Therefore, returning officer, I have heard the parties, considered it transpires that the order may not be well written, and accordingly I direct the authorities to revise the order. Accordingly, I direct the authorities to pass a fresh order
No, he
without
sought-
setting aside
sought for a CC.
that order. That order passed by the court will be sustainable, Mr. Sureka.
Thereafter, he has written.
Yes.
Seeking instruction.
Permission. So there is
Permission.
I have seen that. This lacuna is there. Show me from the order. You file an affidavit.
Thereafter, CAC informed the RO to take steps, Your Lordship. Kindly see.
I've seen that.
And thereafter, this memo was issued.
Without the election being set aside, still you can do it. Nobody is saying that you cannot do it. But without setting aside the same, you cannot proceed. Please understand, Mr. Sureka. Mr. Nayak, you have to set aside. Today,
No, I appreciate what my lord.
I remand the matter without setting aside the order. Or else remand language is different. Remand language itself is different. An order is there.
So it has to be.
I send it to him. You pass an order, I say. How can he pass
I
an order
appreciate Lordship.
without the previous order being set
What
aside?
is calling from
Election, he has been elected. His election has to be set aside. The certificates have to be cancelled.
Your Lordship.
Otherwise, they stand outstanding. He's showing the certificate before this court. Look here. I am the elected member. I am not going to recognize him.
Lordship.
I am not saying anything in his favor. Neither saying nor going against him. Because today is not the stage. Today you come up, you show me the order, then I will consider. I will record your submissions.
Now, my lord, one is.
No, today, no, nothing.
No.
Enough. On the reopening date, you come, whatever you want to say. Reopening date means I'll fix it in after the vacation.
Yes.
Automatically, it will come.
Not to allow them to function as my lord.
No, that order you pass.
Lordship.
I will not pass any order to that effect. Allowing them or not to allowing them to function, I will not.
It has been cancelled. Now, Lordship holds that yes, not in proper manner. Very well.
That is the only order I will grant. I will not pass any other order in this.
Lordship.
4th June is the election date. So 4th June.
The consequence.
Yes. That is only state.
Cannot be held.
Yes. Grateful.
You will reschedule it. What is the difficulty in challenging the issuance of the notice dated 4th March 20
will show this is only, but he has assumed.
I have just.
You see, because of the assistant returning officer's presence in the.
No, one thing I must not accept.
And
what-
once he
what
assumes
you-
office,
yes, yes.
that should
color
have been-
changes, sir.
That should have been set aside.
And not only that, the election, regarding election dispute, up to delegation election, the election commission have the power. Whenever the board constitutes.
That's why I'm asking.
Yes, my lord.
Yes,
Yes.
So that power we have.
Register have the power, but not the election commission.
Come back, whether there was an election dispute raised.
Yes.
If the prima facie does not appear, there is
Yes,
an
yes.
election. You only an investigation,
Yes.
complaint, and you set aside.
Yes. And after constitution of the board and the office bearers.
Deciding that is we
I
are.
will hear you.
Yes, grateful.
Mr. Nayak, you have seen me. I do not hold back.
No.
Whatever I want to say,
Yes.
I direct it, and thereafter you.
No, we always
whatever
we
you want.
always
From the earlier matters.
we always will not pay respect to your lordship.
Grateful, my lord. Grateful.
Yes.
Our submissions in other matters were detrimental to this fact.
Yes, naturally. You had impressed upon this court to proceed in a particular fashion. Now you cannot take a contrary step.
That is,
you had proceeded and impressed upon this court. Take
That is the council problem. And one matter.
wait a minute.
Grateful, my
Lordship,
lord. Grateful, my lord.